Calling to order the regular meeting of the Sunshine Ordinance Task Force. Roll call, please.
Yes, Madam Chair. Member Craven Green.
Here.
Craven Green present. Member Nee excused. Member Cawthon.
Here.
Cawthon present. Member Manny.
Here.
Manny present. Member Washburn.
Here.
Washburn present. Member Caneba. Member Caneba excused. Member Johnson.
Present.
Johnson present. Member Chan. Member Chan absent. Member Goldman.
Present.
Goldman present. Member Williams. Present. Williams present. Madam Chair, we have a quorum.
And Mr. Administrator, is Member Chan excused or is he absent?
Member Chan said he's going to be late.
Okay. All right. Thank you. There have been no requests for agenda changes. So item number 1. You can call item number 1.
Okay. Item number 1 is the approval of December 1st, 2009 special meeting minutes.
Members, I just have some typos and whatnot that I'll give to Chris to clear up. Nothing substantive.
That's the second one.
That applies to the first one as well. Trust me.
I believe the administrator has received a request from Chair Nee that there are some substantive changes to the December 1st minutes that he would like to see happen because of the nature of the substantive request to the changes to those minutes and his concerns about generally the timing with which we get the minutes in order for people to review them and make those changes and have those changes made. I would support a motion or move to have approval of the December 1st, 2009 minutes continued to our next meeting.
Second.
Discussion on that by the members? We'll take public comment on approval of the December 1st, 2009 minutes.
Thank you. Peter Warfield, Library Users Association. I'm not clear if the subject here is whether to table these and consider them another time or whether the discussion here is the content.
I would invite public comment on both issues.
Well, I would certainly agree with tabling, particularly since Chair Nee apparently has said he had some substantive issues. He also tabled for a future discussion these minutes at the last meeting, and I think it would be suitable if he were here, so I support that. I did want to say something with respect to the minutes, which some of you may not have heard since the attendance here has not been 100% at all meetings. And that is that on page 4 of the minutes, and I don't see the page number in your packet, but the 4th page of the minutes under item 3, item number 09044, it says, Mr. Warfield said it was troubling to him that the task force was discussing legislative-related issues on redactions. I believe what I said was that it seemed to me that if the task force was not satisfied with the existing legislation, then it should recommend a change, but that its job is not to legislate, but rather to enforce the existing legislation. And that's reinforced by the remainder of the comment, which I think is fairly clear, and it says, he said the order of determination and the ordinance say that contact information is to be provided, and that should be the case. So I think that needs to be clarified as to what I was saying and what the point of that was. I also believe, certainly, that I made this point at the last meeting on these minutes, and now we'll make it a second time, again, for the benefit of those who either don't remember or were not here, and I hope you'll remember it if I'm not here at the next meeting. On page 8, the 4th paragraph down, and this is underneath item 70906.7. This is crucial, and I think also is something that should be considered as a revision to your order of determination, which also used the same language but got something very important wrong. I'll read what it says now. To Member Cawthon, Mr. Warfield said the issue of minutes was brought up at a recent commission meeting, and during the course of the discussion, it was noted that Ms. Avery said that Mr. Warfield was correct. And then she went on to budget issues, and the issue was not discussed further. My point there was not the major point whether she said I was correct, but that she said I was correct on the question of whether the minutes were legal, and that Ms. Avery herself told that commission that their minutes were not lawful, and that she made that determination after discussion with their attorney and others.
Thank you, Mr. Warfield. We'll
Thank you.
make that correction. To the administrator, Mr. Warfield's comments recollect with mine. Will you make those changes in
I will.
advance of the next meeting?
Yes, Madam Chair.
Any further public comment on the December 1st minutes? Seeing none. Roll call, please. And this is to continue the approval until the next full task force meeting.
On the motion to continue the minutes, Member Nee, Member Cawthon.
Aye.
Cawthon, aye. Member Manny.
Aye.
Manny, aye. Member Washburn.
Aye.
Washburn, aye. Member Johnson.
Aye.
Johnson, aye. Member Chan. Member Chan absent. Member Goldman.
Aye.
Goldman, aye. Member Williams. Williams, aye. Member Kramer Green.
Aye.
Kramer Green, aye. Madam Chair, we have 7 ayes.
Thank you. The next item, please.
The next item is the approval of the January 5th, 2010 special meeting minutes.
I would make the same statement that the Chair Craven Green did. But even though I wasn't at the meeting, I would like an opportunity to go over them before I cast a vote for them. So I would also think that it would be appropriate to continue these until the next time. But I don't know if anybody else got them before, but I just got them.
Is that a
A few
motion?
minutes before. I move that we continue the January 5th minutes until the.
I second. It's
Until
not
the
even in my
February meeting.
package.
Right. Moved and seconded?
That's been moved to second. I think that's wise counsel to allow us to be able to review these. It's. I know it's a time crunch, but it's very important that the minutes are in the packet so members of the public have the opportunity to look at them, as well as members of this commission. I will take public comment on this issue, which is the approval of the January 5th, 2010 minutes.
How you doing? My name is Raymond Banks. I had 2 items on the January 5th meeting. What I don't see is the order of determination under I see determination of jurisdiction, but under 09077, I don't see the order of determination, which maybe I'm not seeing it correctly, was in my favor. Also in 09082, I don't see anything specific to the order of determination. This is motions to find violation, but it doesn't seem like there's an order of determination, and maybe that's my misunderstanding of what's going on, but I assume that there would be an order of determination. Also, I would just like to thank the task force for siding with me. It was a very important issue to me, and I think it's a very important issue to the public and the consumers of services. One more thing, even though I think his name is Chairman Nee, I would like him to be a little bit more kinder to Ms. Williams. I know that sounds like a personal comment, but based upon my observation, you guys are supposed to work as a team, and I felt that that goal wasn't fulfilled in some of the interactions that I saw. Finally, in regards to some of the information in my complaint was supposed to have been confidential. That confidentiality wasn't maintained. In fact, my email address, I Googled my email address, and what came up was this previous action for the Sunshine, so I like for my email address be redacted from the another personal information. I had submitted a request before the information was actually put on the internet, and so I'd like for that to be honored. Thank you.
Thank you. And again, this is public approval, public comment on approval of the minutes. Some of these issues that Mr. Banks raised will be addressed or could be addressed more appropriately in the section discussing the administrator's report later on in this meeting. And I will attempt to recall those and raise those with the administrator during that time. No further public comment on approval of the January 5th, 2010 minutes. Seeing public comment, Mr. Warfield.
Thank you, Madam Chair. The packet that I received has no explanatory document for these minutes whatsoever, and I think that's most unfortunate. It's been 21 days since the date of the meeting, and I think it's very troubling that the task force shouldn't have draft minutes ready. Certainly the law requires that you have draft minutes available upon request within 10 days, posted, not posted, but available on request. So I would certainly like to request at this time a copy of whatever draft there is as soon as possible. And I would support and appreciate the recommendation or the motion that the current chair and the member made with respect to continuing these minutes. Certainly, I think that they ought to be part of the agenda packet so that everybody, not just members, but certainly members of the public, can have an opportunity to review them before approval. Thank you. Thank you. Thanks. I guess I have received just now from the administrator what looks like a draft copy of those minutes. Thank you.
Thank you. Mr. Banks, sorry, you already had public comment. This is public comment on the issue of approval of the minutes solely. That's the only issue. We'll be discussing other issues. You can discuss other issues in general public comment later. Further public comment on approval of the January 5th, 2010 minutes.
Hello, my name is Doug Comstock. As a former chair, I just wanted to commend whoever is doing your minutes. I scanned them quickly and I didn't find any grammar or spelling errors, and I think that's a great improvement over what I used to get. So I appreciate whoever is responsible for this taking a yeoman's effort to make sure that these minutes are very legible. Thank you.
Thank you. Any further public comment? Seeing none, public comment is closed. Member Cawthon.
I just wanted to second what former Chair Comstock said. I was reading the December minutes, and I noticed they were something like 17 pages long, which is just great. I mean, I'm thinking that, if there is a problem with time for the administrator, maybe the minutes could be a little bit less lengthy, and then there might be more time to deal with the ordinance requirements regarding timely provision. But I do think that a yeoman duty was done in the minutes. And the fact is that the Sunshine Ordinance requirements on minutes are really minimal.
Member Williams.
I would just like to say, I just received from our attorney a copy of the minutes. They were not even in my package, and I just got my package today, so I don't know,
It was clear. They're not in anyone's packet. That's why we're continuing it.
Okay, thank you.
Sure. No further public comment, no further committee comment. Roll call, please.
On the continuation, Member Cawthon.
Aye.
Cawthon, aye. Member Manny.
Aye.
Manny, aye. Member Washburn.
Aye.
Washburn, aye. Member Johnson.
Aye.
Johnson, aye. Member Goldman.
Yes.
Goldman, aye. Member Williams.
Aye.
Williams, aye. Member Craven Green.
Aye.
Craven Green, aye. Madam Chair, we have 7 ayes.
Thank you. The next item, please.
The third item is the hearing on complaint filed by Brett Starr against the City Attorney's Office for withholding public information.
Thank you. Ms. Starr, you will have 5 minutes to present facts and evidence in support of your case.
At the top. Over the podium.
My battery is down.
I'm coming here because I asked several years ago to obtain documents concerning the dismissal of an official of the DPT who was under investigation by the city attorney's office in approximately '04. There had been numerous complaints about her actions and non-actions in particular neighborhood activities. She was a citation manager or something, and various levels coming from a secretary on up to the director of the DPT, which means she had the authority to give and take tickets and make sure that some cars got them, some cars didn't. And she got out of hand. And there was an investigation by Geraldine Park Rosen, I believe her name was, after talking to the city attorney's office for about 10 years and them explaining to the neighborhood, NOPNA, that they actually represented the city and not the neighbors, not the residents, even though we're the taxpayers. Though they did investigate her, everything became confidential, and her authority is still intact as far as many of the employees that are still present in the Municipal Transportation Authority are aware of. I'm not part of the Municipal Transportation Authority, by the way. And the same kind of misconduct and corruption is still going on, so we're into finding the documentation of that investigation. One, why is she still an employee? And two, what did it actually say? Because of many things. And so we ask, and we're still waiting. They gave about 4 pages of non-information, even though in the Chronicle they had pages and pages of information that the city attorney refused to give us. So that's why I'm here. And it's become, it may sound like it's confidential, but it's not. It's actually part of what San Francisco is supposed to have, which is transparency and open government. And by protecting this particular employee and probably a lot of other employees, they're continuing the same kind of corruption that's going on. And people who are part of it are very aware of it. Some of the neighbors have gotten threatening notes and letters. I can show them to you if you're interested. I'm going to wait and keep part of my 5 minutes for questioning because I don't know why they're not giving out the information if there's nothing to hide.
Thank you. You will have time for rebuttal, so you can actually use all of your time, but if your comments are complete. I'm not a lawyer. I want to hear why they don't want to give up the information. We've been through this before. I've been here twice before, and they don't want to give up the information, mainly because of the corruption involved in a lot of different officials. And I'm really, really not being one of those crazy kind of people. It really has happened, and it really, every time I suggest to other people that this sort of thing's going on, trying to use language that's very diplomatic and PC, people say, well, why don't you talk to the city attorney or the DPT or the director or the police department or the public works or a lot of other departments that shouldn't even be involved but are because they give it to another department in order to protect themselves, or so it appears. So under transparency and open government, maybe they can explain why they're protecting this particular employee who definitely did things that were not what the citizens of San Francisco and residents want to hear out of their paid civil servants. I can't say anything. I have stuff in front of me. I have papers I can show. I don't want to look like a crazy lady. I want to look like a lady who's trying to get through the government, which is trying to hide as much as possible. I feel that the city attorney's office can and will cooperate if they understand the seriousness of the situation. They're not my enemy or anyone else's enemy. Thank you. Is there anyone here to present facts and evidence on behalf of the complainant? Seeing none, I invite the city to respond. Thank you. You 5 minutes.
Virginia Elizondo from the San Francisco City Attorney's Office. I'm here second time to address the concerns of the requester. As we went through last time, the request specifically was for an internal investigation that apparently was leaked to the press. Again, I have no independent knowledge of these facts. I wasn't involved in this case. I'm merely, the city attorney's representative for purposes of the Sunshine Ordinance Task Force. Anyway, the information came back that there was a report. However, that report is confidential under both the attorney work product doctrine and also under attorney-client privilege. However, the results of the investigation, 2 disciplinary letters to the woman who was the subject of the investigation were released to Ms. Starr, the requester. So I think that gets at least one of her concerns, what happened to this employee. So Ms. Starr was provided with those letters. Last time when we discussed this matter, I explained that regardless of the fact that an investigation or portions of an investigation were released to the press, that does not make the document a public record under the law. Lawyers have an independent responsibility to maintain the privilege. We could find at the time, I looked into this since our last meeting, again, followed up, and tried to determine if there was an investigation into the leak. At the time, there were questions asked, but from the few people who remember this, like I said, the woman who actually was responsible for this investigation is no longer with the office, and in fact, sits on the court bench. Anyway, there was no determination made. They couldn't figure out who leaked the documents. So therefore, we have to assume that the disclosure of these documents were not authorized. Therefore, there's very specific rules under the California Rule of Professional Conduct that the lawyer has the duty to maintain and violate the confidential nature of documents when there is no clear waiver. So, like I said, I think that your counsel's memo addresses that. I addressed that last time. If Ms. Starr has ongoing concerns, then certainly she can make complaints to MTA, or if she thinks that that's not adequate, she can use the controller's whistleblower program if she has concerns about this employee who is, in fact, still a city employee. But she was removed from the position in 2004, 2005, when this initial investigation happened and the resulting disciplinary letters were sent. Have any questions?
We will ask questions after. Thank you. Are there any other parties to present facts and evidence in support of the city? Seeing none, the matter is with the task force for discussion and questions.
I'd like to ask City Attorney Threet. I'm looking at page 5 of the Privilege and Confidential Memorandum. We don't have page numbers, but if anyone paginated...
Mike, Ms. Cawthon?
Sorry. If anybody paginated, which I did, it's page 7, but it's page 5 of the confidential memo. And I was taken by what Mr. Threet said regarding a privilege waiver, and it seemed to me that he had... the relevant documents were obviously leaked to the press. Now the question is, to me, was the leak a waiver, an abdication of attorney-client privilege and or work product? And I don't see that Mr. Threet has exactly come to a conclusion, but I would like to hear again his thinking on this. It's on page 5 of the confidential memo.
Through the chair, Jerry Threet with the City Attorney's Office. Member Cawthon, you're correct that one of the significant issues in this complaint is whether there's been a waiver of the privileges that ordinarily apply here. And with an organizational client such as the city, a waiver can only be made by someone who has authority to waive the privilege. That typically is the highest officer who actually deals with, the public officer who actually deals with the issue in question. So We don't have any information that I know of. I certainly don't have any information as to who may have who may have disclosed these memos to the press. And as the city attorney representing the department has stated, in the absence of evidence that there is a valid waiver by someone who has that authority, the attorney is obligated under state law to keep the matter confidential at every peril to themselves. So the city attorney's office under these circumstances could not disclose the information legally, and any city attorney who did that would be subject to possible disciplinary action by the state bar.
But in the final paragraph before the conclusion on that page that I referred to, page 5, you do say it is possible that the provision of responsive documents constitutes a waiver. However, it's also possible that such disclosures were not properly made by those with authority to disclose. So what you're saying is it depends on who disclosed who leaked the documents to the Chronicle, and we don't know that?
Yes, in terms of the waiver, it does depend significantly on who provided those documents to the Chronicle. For instance, if it was the head of the Department of Parking and Traffic, that might constitute a waiver. But if it was a low-level employee who had issues with the employee in question and leaked them, for some other motive, then that necessarily would not constitute a waiver. But at least I don't know who made that waiver. I don't have any information regarding that, and the city attorney who made her presentation said she did not either.
Okay, thanks.
Member Goldman?
I'm not seeing a waiver here, and I'll be voting in that way.
I have any other comments before I jump in? I apologize. I wasn't here at the last meeting. I was out of town. But I had some questions. And I find it, well, let me first ask the question from Ms. Elizondo, please. Yes. How many documents were responsive to her request?
I actually did not. These were files that were pulled from storage. I personally did not review the files. That was tasked to the head of our MTA. 2 documents that were responsive to a request were released.
So you can't tell me how many were withheld?
No, I did not. Like I said, I did not go and look through the archives for this.
All right. Well, it looks like you are asserting a letter that you've written asserts that. Let's just turn to the documents that were produced. 2 of the documents had information redacted for personal privacy and medical reasons under 6254C. What was the general nature of that information without disclosing underlying information?
Okay, there were 2 requests that, and we tried to sort this out in terms of the complaint that was filed before you. First, Ms. Starr requested the investigation or the documents related to that, and the personnel letters that contained the disciplinary action for the employee, Mary Ellen O'Brien, were released.
And was that information redacted from those 2 letters?
I don't believe so. Then there was information that was requested regarding attorneys or people, Jerry Rosen Parks. Mm-hmm. And there was some personnel information, there were some forms, and there was some information on those forms that were redacted. And that's what I think.
Thank you. I think that's correct. And what was the nature of those redactions?
They were... I'm trying to remember the requests, and I'm sorry, I look at dozens of requests every week as the person who oversees this for the city attorney's office. And so there were, she wanted information about Ms. Rosenpark's hiring and tenure in the office. So there were some personnel forms that routinely redacted. They could have been the Social Security number. Again, I leave it to the attorneys who are gathering the documents to make the appropriate redactions, and I look at them before they go out. But like I said, they would have been the records on her personnel, the personnel forms. They were actually, the appointment documents. Okay. So there would have been the Social Security number.
So it didn't have anything to do, for example, with potential allegations of misconduct or...
Oh, no, not for Ms. Rosen Parks. Right. And the letters for Ms. Bryan that were released were specifically related to the allegations of misconduct, and they were the disciplinary letters, and they were released under the Sunshine Ordinance section that, in fact, does not exempt personnel actions that are, in fact, based on malfeasance. So that's why those were released.
All right. And then with respect to the document that you're not sure what documents were responsive and were withheld, unfortunately, except perhaps for one. I mean, there's allegations that there was a 16-page report.
But there was an investigative report into the allegations that were made at the time in 2003, 2004 regarding Ms. O'Brien's role in determining tickets. Again, like I said, I don't have a lot of time to get into the backstory here. And the attorney who's the head of the transportation team pulled those documents from storage and reviewed them and determined that what there was the investigative report, and that the investigative report, like we've maintained, is confidential. And that the two documents in that file that were were not exempt were the disciplinary letters, which were released.
And that's actually the crux of my issue here, or what I want to get to the bottom of. Essentially, there's, I think, an open question under California law as to whether or not an investigation conducted by a city attorney's office into employee misconduct, once there's been a determination that the allegations of misconduct are not insubstantial. There doesn't have to actually be discipline imposed. That investigation should be released. And so I know there's been at least some litigation around this area. I'm not aware of any Court of Appeals decisions on it, unfortunately, because you get into the situation where if records regarding employee investigations of employee misconduct are automatically shielded simply by the fact that either a city attorney is conducting the investigation or is advising the department on a factual investigation, suddenly all records regarding, or a substantial number of records regarding employee misconducts are allegedly out of the purview of release from the Public Records Act, which I don't agree with. I think, in fact, that the appropriate response is where you have an investigation done by a public entity, indeed even done by the city attorney's office, into allegations of employee misconduct, and that employee misconduct allegation is found to be substantial and or validated, and discipline may or may not be imposed, that should be, as a matter of general course, released. Specifically, I mean, I think certainly with respect to at least the work product in that case, the factual background, those sorts of issues, perhaps or the low work product, I should say, perhaps the higher work product, the attorney's mental impressions, there could be an argument that those should be exempt. But I think at least the factual background in that investigation is critical information for the public to understand and to receive. And so that's kind of my background, the way I approach this case. The issue to me is not really about the waiver, even though that's interesting. Unfortunately, it sounds like we don't have enough facts to be able to decide one way or the other. Members of the task force could draw inferences. I myself am not comfortable doing that on these facts because I don't have enough. But to me, the more important issue is simply the fact that there was an investigation that had some involvement of the city attorney's office does not automatically make this report to me off limits under the attorney-client privilege. I believe its purposes are trumped by the Public Records Act in the case is holding disclosure of information regarding employee misconduct. It's such a vital nature for the members of the public to know that they should have access to that once an investigation has been concluded and there's been a determination that the allegations are not insubstantial. So, sorry, that's a little bit of a statement, not a question to you. So I guess one question I do have is, was the investigation into Ms. O'Brien's alleged misconduct, or substantiated misconduct, I guess we can say, conducted by members of the MTA under advisement of the city attorney's office, or was all of the actual investigation done by the city attorney's office?
My understanding, and again, I did not review these files personally, they were delegated to the head of the transportation team, is that it was a city attorney investigation. It was an investigation by our office. Obviously, probably there might have been some consultation with somebody at the MTA, but given the nature of the allegations, it's not surprising to me that there would be an investigation, a very confidential investigation, just so that they could try to get to the bottom of the situation and sort out the facts. And my concern that you raise is in an investigation like this, like I said, I did not review the investigator's report. There could be allegations, could involve other employees. There are a lot of
Certainly.
of things that could be in there that have nothing to do ultimately with the discipline of a particular employee, that could implicate other employees that in fact could not be correct, for example.
Certainly, and under California case law, if those allegations or those portions of those allegations are not deemed to be substantial or insubstantial, is the word the Court of Appeals uses, that can be redacted
Yes.
and then not produced. I totally agree with that, but that's a separate question. That would be an analysis of the totality of the document and what within that document can be withheld versus withholding of the whole document.
Right. But, under the Sunshine Ordinance, the letters of discipline, the actions specifically directed at the employee, those are not withheld and they were released.
I understand that, but you see this leads into a situation where, say, for example, allegations of misconduct are not insubstantial. There's a lot of complaints. There are, the resources of the city are geared up to do the investigation. Ultimately, the city may find that the allegations are untrue. That does not mean those personnel files are off limit. Right? It means there was something substantial about the allegations, substantial enough to have an investigation and time and resources spent under the Court of Appeal case law. That investigation, the information regarding the allegations of employment misconduct must still be released, even if they weren't found to be substantiated. I should not use that word. Even if they are not found to be true and discipline was not imposed. And so my concern is setting a precedent for situations where yes, it's great you released the discipline letters. Those should have been released clearly. But that doesn't mean that the record of the investigation can be withheld. In situations where there are investigations, as I said, that are not found to be true and no discipline is imposed, there wouldn't be any disciplinary letters. So the quite substantial nature of the allegations would go uncovered, and public wouldn't have access to them. So to me, the position that this is automatically off limits defeats the holding of those cases, which is, when there's been investigations, and those investigations are into non-insubstantial claims, they can be released regardless. So they should be released regardless of whether discipline was imposed or the allegations were found to be true. So that's the difficulty where I am on this issue, and as I said, I think it's an unresolved issue under state law. I know this has been litigated, and I think it's been decided by superior courts or settled. So it hasn't been brought up to look at this tension between the attorney-client privilege and government investigations into employment misconduct.
There's a third issue there, and that is the constitutional right to privacy, as the employees do have. In terms of, I have to say, in all fairness, as sitting in the city attorney's office, the employee also has rights. The employee also has concerns, which frankly were expressed to me, and her letters were released anyway. So, we do have to balance and
Certainly.
sort out these situations.
Without a doubt, and that concern is accommodated by the Court of Appeals decisions, which say, where there's basically no substance to the allegations, it doesn't have to be released. But where there is substance, that does not trump, the employee's privacy does not trump the public's right to know. I think that's clear in the Bakersfield case and the AFSCME case. I have the citations. And certainly, I recognize that, and I'm not just disregarding that at all, but that is why the Court of Appeal has chosen the standard it has. So this is my difficulty. My inclination, to be honest, because Ms. Elizondo has some information, but not necessarily all the information. I think this is a very important issue that really could set a bad precedent if we find that it's automatically off limits. My personal view is that investigations into employment misconduct, whether conducted by outside counsel, hired by the city or by the agency, or whether conducted by in-house counsel, which in this case would be the city attorney's office, should be disclosed after the conclusion of the investigation, where the allegations have been found to be substantial and or discipline has been imposed, Of course, that is not to say that redactions cannot be made to protect witnesses, to protect whistleblowers, redaction to take out information or allegations that have been found to be spurious or without any basis. That under the Court of Appeals decisions can clearly be withheld.
And
that will be, that's really what I believe is a matter of what the law should provide for, and certainly under our Sunshine Ordinance, which is more weighs more in favor of disclosure than of redaction. I think that's particularly the case with respect to an investigation conducted in San Francisco. So that would be my motion at the right time. And I think you'll have time for rebuttal, so you certainly can explain.
I wasn't going to rebut you. I'm happy to look at those cases again. I'm familiar with the cases. Sure. This is why, in fact, we felt those letters did merit release.
Of course.
Separate from the language in the Sunshine Ordinance.
Agreed.
We said we're familiar with those cases, and those letters were just. But certainly, an investigation that is both parts of which are subject to attorney-client privilege and part of which are work product privilege. We did not think should be released.
Right. Well, I think there's different issues. I mean, I think there's the issue of the investigation in general, and I think my position and perhaps the position that's furthest in favor of Sunshine is that where the allegations are not insubstantial and or discipline has been imposed after the conclusion of the investigation, it must all be released. I think that there's a middle ground, which is certainly with respect to low work product information, the factual circumstances, the sort of information that the investigation found, as opposed to necessarily the attorney's mental impression or recommendations to the client. I could see someone saying, well, those should be withheld. So just to make that clear, I'm of the view that everything should be released, but I would understand a position, or I could expect a position that would distinguish between high work product and low work product in terms of the analysis. Member Washburn, and I apologize for going on for so long.
Now, I'm finding all of this very interesting and a lot of issues to think about, but could you explain the difference between a low work product and a high work product?
I apologize. It's basically looking at the type of information that the attorney is dealing with. So if the attorney is doing an investigation, the type of factual information, I contacted 5 witnesses. Witness X said A, witness B said B, witness C said C. I mixed my numbers there, and my letters. That sort of background factual investigation is considered low work product. The sort of part of the memo or any kind of attorney written product that would say, I believe based on the following that here's the liability of the city. The city might be facing liability if we do X, Y, or Z based on those facts. That second part, the attorney's advice and mental impressions, is what's referred to commonly as high work product. And I would invite DCA to read if I've misstated that too. Member Goldman.
I'm not saying Bakersfield or asked me in the binder. Can you summarize those cases for us so we can follow you in your logic?
Certainly, those cases dealt with when you have, they dealt with when you have an investigation. Just generally, they didn't really deal with the issue, as I recall, of who in the government agency was doing the investigation. But when you have a government investigation into employee misconduct, at what point does that information become public? Or should it become public? And the holding of those cases is that where the allegations of misconduct are not insubstantial, so there's some meat to them, either by terms of number or seriousness, they should be produced. You do not have to find that misconduct has in fact occurred before those records become subject to disclosure. There had been a contrary line of cases or Superior Court decisions, I believe, that said, if there's been no discipline imposed, then you don't have to release information about the alleged misconduct. And I believe The Bakersfield case was the most recent, and that was the one to say, no, it's a much more lenient standard, and it's as long as we're not talking about spurious allegations or groundless allegations, even if no discipline has been imposed because the allegations were found not to be true, they should still be subject to public review.
And that's published?
Yes, it is. But just so you're clear, and I want to be perfectly clear about this, I don't believe those cases dealt with the very issue we're discussing now, which is what happens when the city attorney's office is doing that investigation. And so that's where this other wrinkle comes in. But my position is, in order to provide effect to that line of cases, I believe the correct holding should be that even where a city attorney's office or a public, county council, a government attorney is doing that investigation, in order not to defeat the disclosure, that information must be released under the same standards. Member Cawthon?
I just wanted to bring up another issue, which is the timeliness of the response. I believe the request was made on September 4th. Ms. Starr got 3 documents on November 13th, and the city attorney says the reason for the delay is that they needed to assign, I think they took a 14-day extension, but they said they needed to assign particular people to sift through the documents and so forth, and there was a question of a deficit of staff. But I was just looking at section 67.26, which says keep withholding to a minimum. And one of the things it says is that the duty of responding to a sunshine request is the duty of any city employees. So I would be concerned about the length of time, Ms. Dario Elizondo, that it actually took to respond to an immediate disclosure request, which does require some kind of response by the end of the next business day.
I'm happy to address that, and that is, one of the issues I was prepared to deal with last time. It's an imperfect system in terms of how requests arrive at our office. To the best that we can, they're gathered in one place and they're logged. At the time that I become aware of them, many of you know me for years, I'm a senior lawyer on the government team. I have the authority and the responsibility to oversee this. I don't have the time to look for these documents myself. I get them out as soon as they come to my attention, get them logged, get them directed to the place in the office where they should go. And a search like this, well, first of all, a search like this is absolutely not appropriate for immediate disclosure. So as soon as it came to my attention, she was advised that this is not an immediate disclosure request. At first, we thought there were no documents responsive. Again, the people who conducted this investigation are no longer in the office. I tracked down that there would be a box in storage. We got the box from storage. The woman, the attorney who's the head of the transportation team, was the person who was tasked with reviewing these documents. And I remind you, and it's like I said, it's an imperfect world, but our office is facing the same budget issues that every other city department is, and most attorneys in our office now do the job of at least another person. And we get to these things as quickly as possible. Trust me, I'm known in the office as the Sunshine Nag. I send emails, I send calls to remind people to please look through their documents and get back to us. This, was an anomaly. We're much better. You don't see too many complaints in front of you. Usually we're able to respond a little quicker. But like I said, there were several things. But as soon as, we got to got through this, Ms. Starr got her documents. Her follow-up request that had questions and wanted additional information was actually responded to in a timely manner.
So my question, we've had cases before where timeliness of response became an issue, and in one case there was just a voluminous request, and the department simply couldn't go through the documents fast enough, but they did say to the requester that they would have the documents for that person by a particular date. Did you give Ms. Starr an indication as to when she could have the documents?
Once I could confirm when they were going to be reviewed and when the letters were available, we did. Our public information office corresponds with the requesters and tries to keep. And again, there are people with other jobs, and so I advise them what we need to do. They send out the response. So Ms. Starr was in touch with Jack Song, one of our public information officers.
Well, I would say that the fact that the question as to whether the documents existed was certainly covered by the fact that the leaked documents were the basis for a rather lengthy Chronicle story. So I'm still rather concerned about the turnaround time and.
No, the question was whether we still in our office those were files that were sent to storage. Something from 2004 is not likely located in City Hall or Fox Plaza. It's been stored. Unfortunately, the storage is also an imperfect world. Boxes are labeled. An assistant and the attorney perhaps, go through and identify the boxes the best they can. I've had trouble before trying to access boxes that are responsive. I'll request certain boxes only to discover that they're either mislabeled or there's a similar name. And you must know that it costs us $20 a box to get a box and send it back. Again, given our budget considerations, we try to see if we can find them on the computer, if we can find them anyplace else, before we incur the costs of dragging boxes from back and forth from storage. I'm sorry, it's a reality. It's a budget reality.
My recollection is that the Chronicle stories appeared within the past year. Now, I could be wrong
No,
there.
this was a story from 2004.
Were they 2004?
Yes.
So what you're saying is that the document that was leaked to the Chronicle, if you had it you didn't know where it was?
If it exists, again, wasn't familiar with this matter at all. That doesn't matter. If I'm personally familiar with the matter, I send the request. This is what somebody is looking for. Do you have these files? Do you know where these files are? Here's a request comes in. One of the first things I do is I check our records retention policy to find out if they're documents that should be stored, and then I can track down where they might be. And I send emails or I make phone calls to where I think those documents are, and then I ask people. The attorneys are the ones who have to request the documents from storage. Attorneys are in trial or they're have things to do, so request the documents from storage. Sometimes I've requested boxes only to discover that the contents weren't what was supposed to be in the box, or they weren't responsive. In this particular case, the transportation team was responsible for determining that there would be files responsive. The initial answer I got back is, nobody had these files. And again, because they belong to an attorney that, in fact, hasn't been with the office for like 3 or 4 years. So the boxes were retrieved, and I don't even know how many boxes there were, and then the head of the transportation team had to take the time to go through them.
And as I said it before, did you inform Ms. Starr that when she could expect to get something or nothing? And when
yes,
she could,
the best I could. I can't personally sit with somebody and make them do this. I have to ask people to do this. People are very busy. Ms. Starr received regular communications from our office. We worked on, getting somebody to get through these documents and respond. And that's the best. I'm sorry, that's the best answer I can have. And I appreciate if it's not, satisfactory to people. But this is the reality of doing business in this time. If you look at our overall volume of sunshine requests, we get them out pretty much on time. I do my best. I spend 4 hours a day in addition to being general counsel for 2 departments to get this stuff out. So,
thank you. Are there any further questions? I would invite the respondent first, so Ms. Daria Elizondo. You have 3 minutes to present clarification or rebuttal. Then it will go to Ms. Starr, and then it will be public comment.
Okay. I just wanted to address going back to the waiver issue and be really clear on the law. Waiver that is accidental or unauthorized, and as Mr. Threet pointed out, when the city is the client, it's the highest official. That is the two clients in the city are the members of the Board of Supervisors and the mayor, and then you go on down the chain to department heads, etc. But waiver that is inadvertent or not authorized is not a disclosure that is inadvertent or not authorized is not a waiver under state law. There's a case on point. point if you'd like the citation. But as you must also imagine, that we take our ethical responsibilities very seriously. And, our ethics rules require that we have an absolute duty to maintain confidentiality.
Thank you. Ms. Starr, you have 3 minutes.
For all due respect to the city attorney, I don't feel she's qualified to be here in the first place. She keeps saying, I don't know, I don't know, I don't know. And perhaps she doesn't know, and perhaps it's an excuse, but approximately, little after 04, maybe 05, I called the city attorney's office on behalf of some other people asking for this information because we heard that the investigation was taking place, and we spoke to a male Mr. Sullivan, who was a city attorney. I don't know his first name. This was secondhand information, and I understand there's more than one Sullivan. In the past, I've spoken to another city attorney named Catherine Sullivan, so I'm not sure which Sullivan I spoke to, but at that time, he said he was taking over for Geraldine Rosen Parks, who had transferred to Child Family Services. Through other information, I was told that it's possible she left the city attorney's office because of this particular issue that she delved into, and she shouldn't have. This is all hearsay, but I'm putting it out because I think it should be heard. So he was taking over for her, and he said that he would look into it. He said he did look into it, and it was confidential. He had it either on his computer or at his desk in a file because he had he had it right there at that particular time. So this particular person did have that information and refused to give it out. More recently, I spoke to someone who was a former member of the Sunshine Task Force, and he recommended that I pursue this much more stringently because, in fact, Mr. Sullivan, the city attorney who refused information, even though he had it right in front of him, not in some box, in some storage place, refused to give it to me. This person reminded me that there was a transparency and open government to be dealt with, which is the reason that I pursued it, and I pursued it from August on up, and they had all these excuses of how the budget is now. How was the budget then? How was the budget then? The budget was a little bit better, but city government always has excuses for not letting anyone hear what they want them to hear. When the papers that were given to me, the documents were given to me, the actual address of the person involved, address was not redacted. Now, was this a mistake or not? I feel that if I were that person, I wouldn't want confidential information like my personal address given out to the public, even as well as Social Security number. So when you meant Social Security number, didn't you also mean that perhaps someone made a mistake with the address, and there's a lot of other information? I think things are sloppy.
Thank you, Ms. Starr.
I just really need to say something about this. Because of this incident, Mary Ellen O'Brien only went to another
Ms. Starr,
division.
I'm afraid your time is up. Your 3 minutes are up. If I was to give you more time, I would have to give Ms. Elizondo more time.
You can give her more time then too. She's a professional.
I'm sorry. Thank you. It matters with the task force for motion and deliberation. As I mentioned, I think this is a very interesting and tough issue. I would be inclined to move to find, based on the information that we have, a violation of 6721 and 6724 for failure to provide, failure to produce documents, specifically the 16-page memorandum that we all agree exists, but was withheld under the attorney-client privilege, despite the fact that there were significant issues of misconduct investigated and discipline was in fact imposed. So that would be my motion.
I would like to make a friendly amendment that I really do feel that the response was not as timely as it could have been. It took 2 months, and the fact that the city attorney's files are not well organized, to me, is not a reason to excuse them. It seems to me that an office like the city attorney's should have a very good filing system and should know where things are, particularly in a matter that was a rather egregious disciplinary situation. So I'm not really persuaded that it was so difficult to find the files or to even assign the people to it. So I would suggest 67.26 just because it seems to me that covers the fact that any city employee or any employee of the department is supposed to be how is that work of responding to a sunshine request is the regular duty of any city employee. So I would request that we add 67.26 or some other section that refers to untimely response. I think they could have done better.
The maker, I actually don't agree with the amendment, but I believe that can be split off. That motion can be split off. And just for clarification, as I said, I'm not in favor of it, but I think what you want to suggest is a violation of 6721B.
B, like boy?
Like boy, and 6725 for failure to provide documents in a timely fashion.
Fine.
I believe we
Fine
would need a
with me.
second for Member Cawthon's motion. And then this makes it a little bit complicated. We're supposed to have motions before we have public comment, but I believe the two motions that are on the table have been discussed, and at this point we'll take public comment and then we'll return for roll call. So
First motion wasn't seconded yet.
that is correct.
I second it.
Public comment.
Members, Kimo Crossman. First of all, on this issue of work product, as soon as the city attorney shared the report with the department, it was no longer work product. Work product only applies for documents inside the city attorney's office. As soon as they shared their findings, their investigative report with the department outside of the city attorney, work product no longer exists. So I'm not sure why that keeps being brought up. Secondly, the city attorney actually agrees with you on this matter. During the EDU investigation, I put in records requests for the active investigative records for the EDU matter I got, and the city attorney agreed that because they don't have penal authority, that the investigative exemption under CPRA does not apply. They gave me the EDU records as they were capturing them, the EDU investigative records as they were collecting them. So I think that's clear evidence that the city attorney actually does agree that any records they collect during an investigation, active investigation, they have to provide. Again, the Attorney General has weighed in on the investigative exemption. They've said that it only applies for groups that have penal authority. That means sending someone to prison. City attorney can't send someone to prison, so they don't have an investigative exemption. Lastly, I just want to say that I think it's unfortunate that the person the city attorney sends here is not knowledgeable about the matter. That gives deniability. That means they can say, I don't know, I'm not sure, they told me. I think that's suspect, but I think it's poorly designed by the state attorney to send someone that's not knowledgeable on the issue, because they can't answer questions when you ask them. Again, the Attorney General said penal authority only applies for investigative exemption. The city attorney does not have penal authority. They can't send someone to prison. Therefore, their investigative records are disclosable.
Thank you.
How you doing? I don't have the scope of legal knowledge to make some of these claims, but I'm going to make them anyway. as regards to a member of the public and as a taxpayer, I feel that any sort of investigation that's done with taxpayer money, the results of that should be open to the taxpayers or members of the public. I don't want to date myself, but I mean, if you look at Watergate or Jimmy Hoffa or whatever, well, not Jimmy Hoffa, but Watergate, you know, if somebody had the right to privacy to kind of prevent an investigation or the results of an investigation, things might have never turned out the same way. I'm really concerned about the fact that there was a 16-page memorandum and nobody wants to forward that memorandum. I feel that the person was guilty. I think they would be more than happy to forward, I mean, not guilty, they would be more than happy to forward that information or let it be public knowledge that I didn't do anything wrong. I really side with Ms. Starr. I think she's been very persistent and patient. She's waited almost 6 years, and I think, you know, the Sunshine Task Force should side with her. Thank you.
Thank you.
Peter Warfield. I am unfortunately not as familiar with this case as I would like to be, nor have I been able to be fully at the entire part of the meeting. Unfortunately, as I've mentioned to you before, there's a Board of Supervisors meeting happening simultaneously at which I had hoped to make public comment. There are multiple items that are taking public comment there, and I would urge that to prevent this, you go back to what it used to be, which is you met on a different day than the Board of Supervisors meeting. Be that as it may, I nonetheless heard a number of things that I found very troubling. People are very busy, said the city attorney's office. Then she went on about $20 per box to retrieve records. My goodness. And then she herself repeatedly says she's not knowledgeable about this matter. Well, why don't they send somebody who's knowledgeable? I think it's a real disrespect to this body and to the law and to the public to hear these kinds of rather weak excuses, you know, that one might generally put under the rubric of the dog ate it. One of the members referenced 67.26, which I would also like to read from directly. The work of responding to a public records request and preparing documents for disclosure shall be considered part of the regular work duties of any city employee. And no fee shall be charged, and so on and so forth. So I think that it is most appropriate to go on with 67.26 because I think that the city attorney's office and others need to know that coming up with excuses like that, those we have heard here, are offensive and wrong and unlawful, in addition to the substantive issue of whether these records were in fact withheld as you have previously discussed. Thanks very much.
Thank you. Additional public comment?
Hello there, I'm Carlos Castañeda, a concerned citizen. I've been listening to today's comments, and I'm not a lawyer, I don't know all that fancy stuff, but it seems to me that the party asserting the privilege has the duty and the burden of proving the privilege, and that person has to set forth the facts establishing the existence of the privilege. And if this is a hearing today, the lead witness, who would be the deputy city attorney, has said, I don't know the facts. And so the privilege argument must fail. If I'm not also mistaken, the attorney-client privilege is a privilege relating to the advice given by the attorney to the client, or the client asking for advice from the attorney. I don't think that the wrongdoing official here is the client. The institution here is the client. And here we're asking for information from that official. And I believe that the case related to establishing a privilege and the attorney-client privilege and those underlying facts is Deo versus Kilbourne. As far as the attorney work product privilege, that extends to the thoughts, the impressions, the analyses that are drafted by the attorney in furtherance of the advice to that client. I don't think that's what's going on here. I think we have a report here saying, Miss So-and-so, you're busted, you did something wrong. And again, that has to still be something related to the attorney's thought processes in furtherance of advice to the client. But that's not what's going on here. The other concern I have is that the underlying and surrounding facts regarding that work that was created is also not privileged at all. So if I walk up to my attorney and I say, hey, Perry Mason, I've got some papers here for you, that doesn't turn those papers into work product. Those documents are discoverable, along with the reports that were created by the investigators, the list of witnesses that they have, the statements and memos related to that report. Those are also not privileged in any way, shape, or form. I'm concerned as well that perhaps the report needs to be seen in chambers first. Let's take a look at it. And I think a judge would look at that along with the other party and take a look to see what's in it. Let's see what's privileged in here. Let's put that privilege to the test, not just simply saying, hey, it's attorney-client privileged. You have to actually review that document. If I'm not mistaken, I've read the Chronicle a few times, and the city's budget is a few $1 billion, and we're talking about $20 here and there. I've got $60 in my pocket right now, and I can help the city out with regard to those 3 boxes of investigative papers. And I'm happy to give it to you all right now if you want it. But I got stung by this person as well with all these bogus tickets and all these erasing of tickets, and et cetera, et cetera. Privileges also have to yield when it comes to public safety. Oh, the Tarasoff case is informative on that point. Thanks, everybody.
Thank you. Additional public comment? Seeing none, public comment is closed. The matter is back. Matter is back with the task force for vote. I believe the first issue is Member Cawthon's motion for violation of 6721B, 6725, and 6726.
Well, I'd be willing to vote separately on 67.26 because I can see the distinction you're making, because any employee indeed is supposed to follow the rubric of sunshine, but if you go into the police department and you talk to the clerk, that clerk might just as well drop your request in a waste paper basket because they don't know this. But I don't know if that really does apply here. I think 67.21B, which I had a chance to look at quickly, which requires a 10-day turnaround. And then 67.25, which is the immediate disclosure request and a statement of something by the end of the next business day. I think that the delay is totally inappropriate. I think a 2-month delay is not, certainly is untimely, and I think we have certainly a right to, we certainly have a right to slap the department on the hand for what seems to me to be a little bit inefficient record keeping at the very least.
All right, so the motion then for clarification is 6721B and 6725. That's the motion you're making? And I believe it was seconded. Roll call, please.
On Member Cawthon's motion, Member Cawthon?
Aye.
Cawthon, aye. Member Manny?
Aye.
Manny, aye. Member Washburn?
Aye.
Washburn, aye. Member Johnson?
Aye.
Johnson, aye. Member Goldman?
Aye.
Goldman, aye. Member Williams? Williams, aye. Member Craven Green?
No.
Craven Green, no. Madam Chair, we have 6 ayes and 1 noes.
The motion passes. Thank you. And the second motion, which is a violation of 6721 and 6724 for failure to produce responsive documents, specifically the 16-page memorandum regarding the investigation into the employee misconduct.
On that motion, Member Cawthon?
Yes.
Member Manny?
Aye.
Manny, aye. Member Washburn?
Aye.
Washburn, aye. Member Johnson?
Aye.
Johnson, aye. Member Goldman?
Aye.
Goldman, aye. Member Williams?
Aye.
Member Williams, aye. Member Cawthon?
Aye.
Cawthon, aye. Member Craven Green?
Aye.
Member Craven Green, aye. Madam Chair, we have 6 ayes.
Thank you. 7 ayes. 7 ayes. Thank you. And this matter will be, through the call of the chair, referred to, most likely to the Compliance and Amendments Committee for the next meeting to discuss compliance or steps the Attorney's Office might take to review and produce some or all of the information in the memo. That's the call of Chair Nee when he's back in service. Thank you both for appearing. Next item. Actually, it's next item is general public comment. At this point, we'll take general public comment on items not on our agenda. General public comment.
Hello, members. My name is Doug Comstock, former chair of this august body. First, I wanted to thank you all for your service to the city. I think that your service goes unheralded, and I know how much work there is that goes into this, and I know how underappreciated this group is. There's a lot of work that goes on here. I've had a year now of not being your chair to sit back and review what we did and what we didn't do, and going over what we have talked about doing and what we never did accomplish. And I think there's one major area where I feel like I failed as your chair, and that was the area of education and outreach. Pretty much this, as you know, this body is not taken seriously by the city. And that's unfortunate. But I think that you have within your reach the ability to do something about that, and that is through education and outreach. We had talked about having an annual award for the department or a head of a department, the annual Sunshine Award, and I think that's the best way to deal. Since you don't really have any power, you do have the power of the press and of people's understanding, and people do respect Sunshine. So therefore, I think an award for Sunshine would be the carrot that department heads need. And also, I think that there should be a Moonshine Award for the other side of that equation. I think that the Education and Outreach Committee should look into this matter, and that you should set a time for nominations, and the awards should be presented at a press conference annually. And I think it would do a lot to improve the opinion of the public with regard to Sunshine. I think you can do that because there is a lot of respect for Sunshine, and I hope you will consider that seriously. And again, thank you for your service.
And thank you, Mr. Comstock. Additional public comment for items not on today's agenda? Seeing none, public comment is closed. Oh, yeah, Mr. Banks?
Yeah, I don't know if this is appropriate or not, but I just wanted to thank Jerry Threet. I emailed him on New Year's. I think it was New Year's Day. And he emailed me back, and I felt that was pretty nice of him to do that. And I just wanted to acknowledge that fact publicly. Thanks.
Thank you. General public comment is now closed. Seeing no further general public comment. The next item, please.
The next item is the hearing on complaint filed by Kenneth Kinnard against the Human Rights Commission for failing to respond to an immediate disclosure request.
Thank you. Mr. Kinnard, you have 5 minutes to present.
Madam Chair, ladies and gentlemen, it was 2 years ago in 2008 when I first made this request for the information from then the HRC worker Maria Cordero, and I haven't had a response to that since then. But this thing goes way back to the employment in San Francisco of African American workers. More than 34 African American truckers lost their jobs behind rogue employees working for the Human Rights Commission. As I stated before, there was an outside company that lives in San Bruno and controls a lot of has a lot of interest in banking interests in those towns. That has taken over all of the trucking in San Francisco. And one of the things that the contractor did, Rogers Trucking, was infiltrate the Human Rights Commission, certain employees and things like that. Well, when I spoke up and opposed this contractor, Rogers Trucking, well, I was first told by Ed Lee, who was then the chairman, that I might as well just melt my trucks. And I mean, it was testified to and declarations were filed that Ed Lee was in meetings with one of the contractors by the name of S&S Trucking, who's in fact suing the city right now, where they were using racial slurs against African Americans. I mean, the intent of the entire process was to, and they were successful in forcing us all out of business. So one of the things that they also wanted to do was to tarnish the reputation of my company by posting and publishing false information on the internet, stating that my company was doing large jobs as a broker, illegally, in other words, and those type of allegations would constitute violations of the law. So, when I first asked for a confirmation of these documentation, the HRC did send me over a letter last year stating that there's no evidence to that whatsoever. So I asked the HRC, well, then take the document, take that off the internet, stop publishing that hurtful, libelous information on the internet. And the HRC refused to do it. They asked that I would have to come in and make some sort of motion. Well, they are the ones that are injuring me. They're asking me to spend my time. I'm only one person right now. I'm trying to rebuild my company. We were the largest black trucking company in San Francisco. We had more than 30 pieces of equipment and had 38 employees. This is the damage that has been done. And so now, at the meeting last week, I did send another request over on January 6th again to the HRC, which was for immediate disclosure. They haven't responded. And by this commission letting them off the hook last week, what we're going to see now is just continuing fraud. They're going to try to come up with something to try and change history. I'm saying that even the HRC says that there's no information to cover that, and also the arbitrator said that there was no information like that he'd ever seen in his arbitration finding. And so I just want to say that the HRC just continues to keep this thing going on and on. In the meantime, my family is being liable. We've lost jobs. We've been blacklisted in the trucking industry by this contractor, as I told you, Rogers Trucks and Equipment. And all of the black truckers, as I said, have been basically forced out of business. There's no one to look up to for the young truckers who try to go out and get into this business. I mean, they haven't even been warned of what's in it for them right now. There's a few young truckers, black truckers, that have also did the same thing that we did, put their life savings up and made investments. And they're just going to run into the same thing unless something is done now. So that's why I came down here to try to start somewhere to end this and deter these type of rogue employees from doing these illegal things and committing this type of fraud. So I hope that the Sunshine Ordinance Committee will do the right thing and find the HRC in violation. I have, as I said before. Thank you.
Thank you. Is there anyone here to present facts and evidence on behalf of Mr. Kennard? Seeing none, is someone here from the city? Thank you. You have 5 minutes.
Good evening. My name is Melinda Canias. I'm here from the Human Rights Commission, and I'm glad to be before you this evening. I wanted to respond to Mr. Kennard's allegations. He said quite a bit. It seems that if I was in Mr. Kennard's shoes, I would be upset as well. And he has made several requests of us through the years that we have responded to. And I would like to just say that I believe we have responded to him the best way we can. and I have ample information to show you tonight to that effect. Also, I just wanted to go over the things that he said, that in March 2008, he first filed a request with the Human Rights Commission. I'm guessing to the certification unit, and at that time, we had a different manager. And he also went on to say, he kind of went back and forth into his allegations talking about Ed Lee, who was a previous director of the Human Rights Commission that was in the 1990s. And then he also said S&S Trucking was successful in getting all the business of the truckers. Mr. Kennard definitely has a great knowledge about the situation he was in, more than I do, actually. And I say that only because, just to put this in context, his requests for documents have been duplicative. And so that is the reason why I believe we have given him all the information that he has requested. And there is no other forum for me to, there's no other way for me to explain that to him over and over again. And I would like to show that to you. And you haven't seen some of it before because through the years, we've gotten many requests from him. And I say the HRC before I was working for the Human Rights Commission and up to now. And those in the past, persons that he has received information from in a timely manner are no longer working with the Human Rights Commission. But I see that his requests were given to him, the response to his requests were given to him in a timely manner at that time. Fast forward to the last year, I was tasked with providing him the information he needed, and I believe I have given him those informations several times, and I can show you again that I can't produce evidence for him or information for him that I don't have. And so what I was able to do at that time, he requested, on one of the requests, he asked for the files for different trucking entities, and we were able to give him all that information. And so with him asking for more of the same, I'm at a loss to show him how I could give him the information differently that he's already asked for. So I just wanted to give you that background. And also, I'd like to say, in working for the Human Rights Commission, I manage now the certification unit. We certify local business enterprises in San Francisco in order for all the city departments to use and participate, use small business owners here in the city on city contracts. So my job I see as helping individuals of San Francisco who have small businesses, and basically a win-win for the city, that when the city departments have a bid for either product or services, small business can get in there and make some money, and that keeps the money in the city instead of going out. So unfortunately, Mr. Kennard has had a situation where his business was not successful, and for that I am sorry, because it does affect San Francisco. It affects each and every one of us. And me at the Human Rights Commission, I know I'm speaking for myself, but as an employee of the Human Rights Commission, I see it's my job to help small business owners and individuals. So I take it personally that I'm not able to get the information he would like in a timely manner. And I'm going to say that because I fail to understand how I could give him the information again and again and again. So that is my only reason why, again, he doesn't have the information he wants, because we've given it to him already.
Thank you, Ms. Kenya.
Yes.
Is there anyone here to present facts and evidence in support of the study? Seeing none, we may have questions for you, but you can step away from the podium for now. The matter is with the task force.
I had a question for...
Don't go too far.
I had a question for both of them. Mr. Kennard, first, could I ask you, what documents do you feel you didn't get that you feel exist?
Well, my request was clear. They published libelous statements on the internet stating that when I filed for recertification, that they discovered that I was doing large jobs, that I wasn't a viable business and that I was doing large jobs.
Right. You were looking for verification in documents that led to their statement.
Well,
correct?
what I was trying to do was say I wanted those illegal statements pulled off the end to the publishing of those illegal statements on the internet. That's what I was trying to do. I said, if you don't have the documentation to support those statements, then you should pull those from the internet. And another thing I take umbrage to really is that my business is successful. I mean, I can't help it if Ed Lee, as a result of that white contractor, blacklisted my company. You know, I can't help it. They took all those jobs from me. I've got proof of that. I mean, for me to go and dig all this information out.
No, Mr. Kennard, what I was trying to find out is what documents do you think exist?
There are no documents
that underlay what was stated in the minutes. Could you say you're not getting the documents? That's your complaint.
I'm stating that there are no documents that exist to support those allegations that the HRC was publishing. And so what I was trying to do was come here and get you to support me in this by saying that by having the HRC come out and be honest, there are no documents to support these slanderous allegations that other people are mentioning to me and saying that I'm not fit to be in business because I've done these illegal things. So I was trying to come here to get them to come forward and say there are no documents to support this, and to answer the questions properly are either be found in contempt by the Sunshine Committee. But that's what I was trying to do in this particular case.
I really have great empathy for your situation.
It's worse
but the
than
thing
that.
of it is that our role is, if a document exists, to require the department to produce it. And okay. Ms. Acanios, could you come up for a minute? I'd like to know, A, what you did produce, and could you just brief it out to us? And
Sure.
B, what do you say to the fact that he believes there are documents that exist that buttress your statement that he's not a trucker but a broker?
Right, and just for clarification, this is only with respect to the requested issue, which is documents related to a report in HRC's draft minutes of January 13, 2005, which stated that P&K Trucking, quote, was not longer operating as a trucker, but rather providing brokerage service for large contracts. So what documents were provided in response to that? Yeah, just to make it clear.
That's what I just said, that I would like to know, A, what you provided him, and B, if you have any documents that led to the statement on the internet that Mr. Kennard's company is not a trucking company, but indeed a brokerage firm. So, number one, what did you give him? Number two, do you have any documents to prove the statement on the internet?
So I just want to be clear about what we're referring to. The documents on the internet was the January 2005 minutes of our commission meeting. That was an overview of a hearing that took place by an arbiter, Harry Epstein, I believe his name is. And after he had reviewed documents, he had agreed with the Human Rights Commission that Mr. Kennard was not operating as a trucker but as a broker. And the Human Rights Commission, as this relates to certification, his category that he was certified in was as a trucker, not a broker. We don't certify brokers. So he would have had to have his trucks and not just sub them out by making a call to different trucking companies.
Do you have documents that so state that underscore what you said in the minutes?
Right. So
that's what he wants.
Correct. And so that is some information that he would probably have to get from Harry Epstein.
From Harriet?
Harry.
Right. Oh. Did you tell him that where he could find it?
Yes. Actually, and this is what I mean. I am new to his situation this past year, and he knows, I think that Mr. Kennard is assuming that I know the thread of the years of that this event, situation, this difficulty that he's been having with his business, that I understand the whole thread of it, and I don't. He knows more about it than me, and I think that he was assuming, not to get too much off the point, but that certain truckers had long-standing businesses and changed their names, and I didn't understand that. He asked for information that that didn't have information for. So for this particular
but what you're saying is
request, yes.
What you're saying is that a document does exist, but that you don't have it.
I'm not saying it does exist. I'm saying
you're directing him to a person who would have it if anybody had it.
I would imagine so, yes.
Well, are you willing to work further with him to see that he goes to the person?
Definitely. I would like to work with him in a way that gets him the information he needs if I don't have it. I think over this year we've gone, I've had many conversations with Mr. Kennard. I would like to work with him moving forward, and really understand what I could provide for him that's useful, and what he requests in writing, and make that clear and doable for him.
So, can I interrupt Member Cawthon to follow up? Member Cawthon, may I interrupt for just a minute?
So that I just wanted to finish up before Ms. Craven Green. So that you're willing to work with him to see that if this I didn't know who you said, this Harry
Epstein,
okay.
Yes.
If they existed, if they have the documents, you're willing to work with him and them to see that if they exist, he can get them.
Yes.
Okay. Thank you.
Who is Harry Epstein? Who does he work for, or at that time?
Independent arbitrator, I believe.
Right, and so you went.
I would have to go, and I can't be sure.
So as I understand it, the HRC hired or contracted with this arbitrator to review information regarding the certification. Would that be accurate? Or
I don't know if it was a certification. I don't know exactly what issue it was. I don't think it was a certification. It may have been the operations of his business, but I'm not positive.
Right. But so it sounds like to me that HRC contracted or hired someone to investigate P&K trucking to some extent.
I'm not sure if he was an investigator.
Or arbitrated a complaint, perhaps. I mean, there was some. You had to go to Mr. Epstein and say, here's an issue for you, right, to arbitrate. That had to come from HRC, is that correct?
See, this is, I don't want to speak out of turn or say any information that is misleading to all of us. The person who has that information no longer works for the Human Rights Commission. And so I'm going on information that that is like third hand. So
okay, all right.
What I could do is work with Mr. Kennard and see if we can get in contact with Mr. Epstein.
I guess my concern is that it would seem to me that HRC would have itself the documentation, initiating, the contact, receiving a report back from Mr. Epstein, underlying documentation that was provided for the commission meeting. Mm-hmm. I don't know if those exist, but it would seem to me they'd be more than likely that those documents exist and should be in the possession of HRC. Has there been a search for those documents by HRC? Again, I'm not the first person who handled it. I understand. Or the second person. I'm the
You don't
following
know. Up. I don't know where they exist.
All right, but have you taken any steps to see whether they exist?
We have done preliminary searches. We have gone to the archives. We have. I actually did talk I even talked to the person who was handling it before, and she wasn't able to give me information as well. So, I mean, I'm willing to still work and find out where we could possibly find this.
Okay, I'm sorry. So I just want to be clear, and we're only
Sure.
dealing with this very. I understand there's a context to this, and there's
Yes.
a number of requests. This
Yes.
very narrow request, this issue about documentation regarding the statement made at the January 2005 HRC meeting, and this is a recent request. What has HRC done to comply with that recent request?
Again.
Now.
Right. Again, now I am willing to work with Mr. Kennard.
I understand. I hear that. What have you done to respond to that request? Very clear question.
Okay. We have made an effort to find the documents, and they don't exist that I know of.
Okay, and what effort was that? This is exactly what we need to know.
Right. To go into archives and find them.
How did you
I don't
search?
know where they are. I'm sorry?
How did you search?
We have we're contracted with GRM, which is a paper storage facility.
Mm-hmm.
And we ordered boxes, and they're not able to be found.
What boxes did you order?
What we can do is I can look in another area. I've only looked in the certification because that's my area, but I can request it in other places.
Okay, so what did you request from certification? What specifically did you look for?
His file.
Whose file?
It may have been in his file.
All right, so
P&K, yes.
All right, so what
P&K
you've done
trucking.
is you went to the certification and said P&K Trucking and pulled that file, and there was nothing in there regarding this
Right. And
commission
probably
meeting.
because it doesn't have, because the issue doesn't have exactly to do with the certification.
Okay. All right. So what other areas can you look at that might have information regarding this commission meeting and the supporting documentation for that meeting?
The only thing I can think of is we can contact Mr. Epstein, and if we have any files where there's been complaints, just various complaints to the Human Rights Commission, I could look in there. Again, I'm trying to figure out where a place would be that it could be stored.
All right. Is there perhaps a storage place where you deposit agendas and materials submitted for hearings? For example, if I want to go back and ask.
Right. That's what I'm hoping that I could.
Okay.
Find that. I wouldn't know where to.
So it sounds like there's two areas you're going to pursue.
Mm-hmm.
The first is you're going to try to get in contact with Harry Epstein, who's a third party, but find out if he has any files with respect to this issue. Correct?
Right.
And the second thing you're going to do is look to see if there are in storage or readily available documents regarding this commission meeting.
Yes.
Is that correct?
I'm just writing that down.
All right, certainly. Other than those two areas, is there any other place where you believe there might be documents relative to this commission meeting and the whether it was an investigation or arbitrage or whatever it was that took place with respect was discussed in January 2005? Anywhere else?
I will leave it. I can't say specifically because then I will only look in that area. But in general, I'll say any archive that it may be in that the Human Rights Commission may have in the office or in archives.
All right, so you're going to pursue that. You're going to think about that and pursue it.
Mm-hmm.
Okay. Here's my issue. I understand there's a lot of requests, there's a lot of backgrounds, but what we have in front of us is a narrow issue, and it seems to me that first of all, there was a failure to respond to the IDR. Do you understand generally what the department's response, what the department is required to do in response to an IDR?
Yes.
Okay. And did you respond to Mr. Kennard and say, we're working on this request, it's going to take us longer than 24 hours?
I didn't have contact with Mr. Kennard in the last 2 weeks. However, I did have contact with him before and really wanting to work with him, not able to, however.
I understand that, but this is a very narrow, and I understand that, but the law requires if a department receives a immediate disclosure request by the close of the next business day, you're required to respond by either producing the documents if possible, but if not possible, letting the requester know why it's not possible and that you will instead respond within the 10 days required under the statute. And that has to be done within 24 hours. Now, if you have an email, you can send an email. If you have a fax, you can send a fax. If you only have an address, you need to respond to that address. So do you understand that?
Yes.
Okay.
And I also, Ms. Craven,
yes.
I also think this is duplicative. I know that this request, because I can't, and I'm kind of thinking on my feet here, but I do have response to his request for this January 13 meeting minutes. I don't know, maybe 6 months ago, actually.
Okay, I understand that.
Show you that,
and that would be fine. But we don't have that. We don't have that before us. So the issue is your response to the IDR could in fact be, here are the documents we produced 6 months ago in response to this request. But you have a duty to respond. So that's what I just want to make it clear to you, is that there's a duty to respond, and it's not a duty to go, pull all the documents from storage within 24 hours, but it's a duty to get back to Mr. Kennard within 24 hours and say, here's what we can do, and here's when we'll have it done, pursuant to the timelines in the statute. Even if someone submits a duplicative request, you still have a responsibility to respond, okay? And that wasn't done here, so there's been a violation of that provision. I would recommend that you keep, especially where there's frequent requesters, I would recommend that you keep track of what you provide so that if you believe something is a duplicative request, you don't have to pull it from storage. You can simply copy it again and provide it to the requester. I'm not sure that's you allege that's happened. Mr. Kennard doesn't say one way or the other, but that would make it easier of an administrative burden on you. Simply because something is a duplicative request doesn't mean you can ignore it or not respond. You still have to respond. But you can do so in a way that minimizes your administrative burden, for example, by keeping copies of what you've already produced. Okay. And the other issue is just to make our job easier, in case you guys come before us again, what we had requested from you was a written response or a response in advance so that we could look at the material. If you say we have 200 pages of documents that we've already produced to Mr. Kennard and it's duplicative, submit a copy of that to our administrator in advance. He can put that on a CD and mail it to us, or he can have it available on the website so we can look at that in advance. It makes it very difficult if you come to our meeting and say, I have proof here that we've responded. We don't have that. We haven't been able to look at that. It doesn't help us reach this issue to say, yes, HRC has complied, or no, HRC has not. So can we do that in the future?
Yes.
All right, I would appreciate
I'm happy to do that.
And I understand you have burdens on your department, but this is, and so we don't, we make our time the most effective possible. And that's been very difficult here because we don't have a written response from HRC and we don't have the proof that may well exist. So of a response, or may not exist of a response. We need the proof. All right, so I have no further questions. Member Clausen?
I just wanted to make a little pitch for the committee that I chair, which is the Education and Outreach Committee, and we have been doing presentations on the Sunshine Ordinance, so I'm just letting you know that if you're interested, you should get in touch with Mr. Rustum, our administrator. We certainly can make it in particular areas about how you respond to a sunshine request. There are several ways that you can do it, but knowing the requirements is really important. So that's an option for you also.
Thank you.
I'd like to say to Ms. Kennard, I know that you are fairly new to the HRC, but during the time of 2005, I was in the career of teaching with truckers in the meetings and there, and there was a lot going on, which a lot of minority truckers did. So this is really, really important issue with all the building up in San Francisco, for everybody to, with this economic thing, to get their fair share of money coming in. So I know you probably don't know, but it was a big mess during this time, 2005, with decertification and the loss of black truckers, which includes Willie Radcliffe and all of them. So it was a big thing. You probably wasn't here and don't know the whole scoop. But I appreciate you coming here for what you do know. But being on the inside, I know that there was a lot going on with HRC and a lot of complaints. So what they did with this information is probably going to be difficult for you to find it, because a lot of people have been looking for these types of information. So I appreciate you coming here for what you know, so we can try to get this fair employment for everybody. Okay, thank you for coming.
All right. Thank you. At this point, Ms. Candidates, you have 3 minutes if you choose to provide rebuttal or closing statements.
I just wanted to say that I think this body is an important body. I think it's important to get the people's information to the people. I also think that it can act as a body that can get individuals working with departments. And so that's what I would like to do with Mr. Kennard, if, moving forward. So that's all I wanted to say.
Thank you. Mr. Kennard, you have 3 minutes for rebuttal.
I did talk to as I stated before, the arbitrator in his findings, which I'll send a copy along to you, stated that there's no documents that he ever seen that refer or respond to those requests that I did make. Man, I can say that the HRC has exhibited a strange type of discrimination. It has allowed other races it has secured the rights of other races, but it has excluded African Americans. And this is a problem. I mean, we have a whole group of people that have been excluded from the workforce in San Francisco. And it shows by the outmigration. And as I said, there's a case going on now in Sacramento in district court regarding Caltrans being sued by the general contractors. And they state that there are no complaints. The Pacific Legal Foundation states that there's no complaints that have been filed by minorities. Well, that's true, because agencies like there are complaints that have been filed, but agencies like the Human Rights Commission, like the MUNI, and like the FDA have suppressed these complaints. They have denied people like myself and others a voice, a due process right, free speech, and the right to file complaints, and the right to be protected. And this thing is going on. This is why we've all been put out of business, as I said before. But I'm an ongoing business. I have a truck. I'm still trying to get my business going again. I plan to get it going again. And I just don't take kindly to someone saying that we're unsuccessful. We're successful, but we've been beat up on by people, and the things that they're doing, as I stated before, are illegal. And that's what we want to get out there, and we want to get redress for the damages that they've already done in the past. Thank you.
Thank you. I'm afraid not. I'm afraid not. No, I'm afraid not. I'm afraid not. We don't have. That's not in our procedures. If there's a question for you, sorry. That's your. All right. The matter is with the task force for motion and deliberation. I would move to find. Well, first of all, I'd like to tell Mr. Kennard that requiring an agency to remove something from a website or issues of defamation, that's not within our jurisdiction. We cannot do that. That's simply something we cannot do. The only thing we can do is to request a document, comply with the law, a department to comply with the law, produce documents requested. And that's what we're trying to do here. I think there's been a violation, unfortunately, of 6721 and 6725 for failure to comply with the immediate disclosure request and failure to provide responsive documents. I think there's been an admission that neither of those were responded to by the Human Rights Commission. That would be the motion. I would also recognize in the motion that the HRC has stated they are willing and able and will work with Mr. Kennard to get these documents to him as soon as possible.
Second.
Moved and seconded. Is there further discussion? Public comment on this item? This is public comment on this item.
Yes, I just want to state, just listening to the lady from the Human Rights Commission, I'm just shocked. You know, she seems to make it really an overly complicated issue. I'm glad that you were able to really focus in on what the issue was, but there was a statement made in a meeting in 2005. I got that much. There's supposed to be some foundation for that statement. The foundation for that statement was in the form of a contract with someone named Epstein, and then the young lady expects me to believe, or members of the public to believe, that we can't find these sort of documents. I'm really glad that you're making a motion to ask them to come forth with this information. I mean, if I were in their shoes, this is a hypothetical, I wouldn't want to come forth with that information because it could be libelous, it could be, you know, this is a litigious society, and they could be held accountable for doing something that they shouldn't have did. She keeps saying that she wants she's willing to work with this individual. But I just think that, you know, it's not really rocket science. This is not an extremely difficult thing. I'm just really glad that the Sunshine Task Force has decided to make sure that these documents come forward. And if these documents don't exist, then Mr. Kennard has to take some other sort of action. But I really think it's important that they come up with this information to find out that African Americans have been systemically excluded from a portion of business here in a city such as that is progressive as San Francisco. I'm just appalled. I'm appalled by the fact that it's done by the Human Rights Commission. I didn't know they had the authority to certify businesses in order to make them competitive in the market. This seems like kind of a really sophisticated form of Jim Crow. And I just have to call it what it is, spade a spade. Thanks.
Thank you. Further public comment? Seeing none, the public comment is closed. Roll call, please.
On the motion, Member Cawthon. Aye. Cawthon, aye. Member Manny.
Aye.
Manny, aye. Member Washburn.
Aye.
Washburn, aye. Member Johnson.
Aye.
Johnson, aye. Member Chan.
Aye.
Chan, aye. Member Goldman.
Yes.
Goldman, aye. Member Williams.
Aye.
Williams, aye. Member Craven Green.
Aye.
Craven Green, aye. Madam Chair, we have 8 ayes.
Thank you. This matter, through the call of the chair, will likely be referred to the Compliance and Amendments Committee for discussion on the status of the investigation into the other potential sources of these documents and when those might be reviewed and produced if they are responsive. Thank you both for appearing. I would declare a 5-minute recess for the next item. We're back in session. Thank you. Next item, please.
The next item is the Supervisor of Records report.
Thank you. It is here in our packet. Do we have someone presenting it?
I did not invite the Supervisor of Records. I did not get any direction from Chair Nee.
Well, typically we can't have the report without the Supervisor of Records being here. So my view, the fact that it's on the opinion would mean that an invite would go to the Supervisor of Records?
Madam Chair, what I'm told is Chair Nee was going to invite the Supervisor of Records.
All right, so you were under the impression that Chair Nee would be making sure the Supervisor of Records was invited, and you don't know if that has happened.
That is correct.
Well, unfortunately, Chair Nee is excused from this meeting. He, I believe, will be back for the next meeting, so we have no information as to whether or not the supervisor of records was thus invited. That is very unfortunate for those of us who spent time reviewing it and members of the public who are here to comment about it. I share in what must be your frustration that you may well next express to us directly. I will take public comment on this item.
Members, Kimo Crossman, I would ask that you continue this item so that the supervisor of records can present this report. This is actually the second time this item has come up, and the second time the supervisor of records has not shown up to defend her report. Again, I think it's important that she discuss her findings with you face to face. I can tell you that there's a couple patterns though that are happening here. Basically, what happens is a department doesn't respond, it doesn't respond, and then a member of the public goes to the supervisor of records, and then suddenly the department provides the record. And then the supervisor says, oh, it's a moot appeal because you got the record. Well, yeah, you got the record after you appealed to the supervisor of records. You actually had to appeal to the supervisor of records before you could get the record. But then they can say, well, it's moot because you got the record. So from paper, it looks like there's all these spurious requests, when the reality is that these appeals are only being put in after the department has had numerous notifications, and again, only after the department provides the record, then the supervisor gets back to you and says, oh, well, I understand you got the record you asked for, so this is moot. So that's just one of many problems. The other problem is I asked for a Word version of this document, and they will not give me it. They will not give me the Word version of this record. It's a PDF file. As we know, the Board of Supervisors unanimously directed that metadata should be provided, native file format should be provided. Not only have you found that on many occasions to be provided, but even the Board of Supervisors unanimously made that decision, and yet they refused to provide it, even though Sunshine provides that any format requested or easily generated should be provided. Easily generated means you could scrape out the metadata if you wanted to with a metadata removal tool that's free from Microsoft, and then provide the Word document. The reason I want the Word document is because I want to put my comments in the report in writing. I can't. They only have a PDF and they won't provide it. So I would ask that you continue this item.
Thank you. Additional public comment on the supervisor's report.
Peter Warfield. I certainly think it's unfortunate that the supervisor of records is not here, and apparently not here for a second time, to discuss and present and answer questions about the report for your body. And I am glad that the supervisor of records appears to be, in some cases, intervening with departments so that at least some progress seems to be made. There seems, to my recollection, to be a time when the supervisor pretty well sided with departments and said, sorry, you're not entitled to the record. This certainly happened to me the one time that I applied to the supervisor of records, and it was the very last time that I ever went to the supervisor of records. Part of the problem at that time, and this was quite a number of years ago, was that the supervisor of records under the law is supposed to be providing a very quick answer, I believe, under the statute within 10 days. At the time when I called the supervisor of records to find out how it was going, it was something like 8 days in. I was trying to understand where the progress was. Oh, we never got it. They then figured out that they had gotten it, but that it was still sitting at the front desk. And when I noted on a subsequent phone call that there was actually a time limit, they told me, oh, we never meet that time limit. As though it was simply a routine thing. Now, one of the things that I've noticed is that there are quite regularly in these reports in the past, and I believe in some of them here, an omission of dates, so that you can't tell when the supervisor of records was asked for an opinion and how long it took specifically for the supervisor to give an answer. And I think that's extremely important because this is supposed to be a kind of an expedited procedure for those who undertake it. And in my case, not only did I not get what I wanted, but it took, as I recall, something like 2.5 times or more. It took closer part of a month to get any kind of a written response, which I understood was to be provided in 10 days. So I would urge you to look and see whether this report actually shows that the supervisor of records is complying with that all-important promptness requirement under Sunshine in every case. Now, in some of the cases, there are dates indicated, and it's one of those, well, we didn't have to go any further with it, but there seem to be, without having checked it thoroughly, there seem to be some instances where no dates are clearly stated as to when did they get the request and when did they answer. And that's a crucial part of this report, which I think you should insist be provided and be checked, and you yourselves, in commenting on it, ought to take that aspect of it very seriously. Thanks very much.
Thank you, Mr. Warfield. Additional public comment? Seeing no public comment is closed. This matter, without objection, will be continued to the next full task force, and I will direct Mr. Rustam, absent some overriding order from Mr. Nee, to please invite the supervisor of records to present this report at the next full task force, and to please follow up the supervisor of records in advance to get confirmation that Ms. Jessen will in fact be here, and we will not have to copy all this paper, waste more trees, and waste more time. Thank you. Without objection, that matter will be continued. Next item.
Next item is the Ethics Commission's proposed rules on handling sunshine complaints.
Thank you. Member comments? Was there discussion on this item at the last full task force meeting?
No, Madam Chair.
Was there an action plan as to what we should do with this item discussed at the last meeting?
It was late in the night and everybody moved it without objection, I think.
That's not my
Member
memory.
Washburn?
I know it was very late at night, and I think everyone was exhausted, and we continued it for this week. We didn't.
Continued it.
We absolutely didn't pass it. I know that Member Nee has a number of concerns about this.
Right.
Yeah.
He meant passed to this month.
Passed to this month, right.
Yeah, I believe that the comments, the only discussion in our minutes is that Mr. Warfield made a public comment that the topic calls for a special meeting, and Ray Hort said the document needs to be put on the web. This is a very significant set of recommendations that we've received. I know that members Johnson and I believe members Cawthon have looked at this issue and submitted comments, I believe, to the administrator. Those comments are not included in this packet.
That is correct.
We need to get to this. It's a very important issue. We don't have all the information for all the members' comments that are here, and I believe Member Nee also had some serious concerns, and there are no comments from him either. I will move that we continue this to the next meeting with the direction to the members that we need to reach resolution on this. It's been continuing far too long. The administrator shall include in the packet all comments submitted by the members so that we all have them before us, and that if any member wishes to provide written responses, to provide that to the administrator in sufficient time so that it can be included in the packet.
Okay, I would second that. if you're finished.
I am finished, but I certainly would like to hear from members of the public as well. And again, with my apologies, it's the continuing nature of this item.
Kimo Crossman, I would ask that the committee consider including the written comments from the public as well on this matter in the meeting packet.
Agreed.
Thank you. Mr. Grossman did come to the last Sunshine Task Force meeting and specifically asked that more than a 15-minute discussion be allocated for this issue, and he volunteered to attend the meeting and bring any relevant parties that need to come to it to invite them. He spoke about that at the general comment. That's why it wasn't in the minutes on this particular item. I know that he's also reached out to some members of the task force and asked to meet with them individually to talk with him about his concerns based on his expertise of this issue. One of the biggest issues that I can just point out to you, and I think this has been put in writing by Mr. Doyle, but it's on page 2, section 2, at the end of it. It says, an action taken in good faith, reliance on the advice of city attorney cannot be willful violation of sunshine. So that basically means, well, we know, we've seen what that's all about. It basically is a huge loophole. It's basically what allowed all the torture stuff that's happened at a national level to go forward. And if you get a memo from OLC, then you've got the golden shield. And so there are definitely some significant problems with these regulations. The good thing is the ethics only meets once a month, and I think they even canceled their most recent hearing, so they're not actually pushing very quickly to get this resolved, as far as I know. So again, I would encourage that, what Mr. Grossman was asking for, I don't know that that's possible, but he was actually asking for a separate meeting to discuss this issue. But I'll let him know that the task force is open to receiving written comments as well. Thank you.
Thank you. Additional public comment?
Peter Warfield, thank you to the chair for the comments. I think she used an F word like frustrated. I forget now which F word it was. I think another F word might be fed up. It seems like this commission's, this body's professionalism. There are a lot of issues and a lot of problems, but when the basic, simplest mechanics don't seem to be able to be managed, I think that's very unfortunate. I did hear a piece of a discussion about whether Mr. Nee had invited the city attorney. It seems to me that that should be something that nobody has to take a special effort to do when there is a matter on the agenda, and that the body and its administrator or the clerk's office should see to it that there's staff enough and coverage enough to take care of the mechanics. Certainly the comments here I would be very interested to see and to have before the public, and I appreciate that that seems to be the direction you're going into. It seems to me also that there should be a little bit more clarity with respect to your agenda item. Are you just simply discussing these? If an action is to be taken, is it a possible recommendation with respect to what these rules should be? I imagine that's perhaps what's intended, but it just doesn't say that in the agenda item. I certainly think that this group should consider making its input and providing its input on this matter so that it has its opportunity, presumably after thorough discussion and input from the public, to let the Ethics Commission know what this body thinks, and certainly that's within your realm of scope of operation under the Sunshine Ordinance Task Force. I would agree with the previous speaker that that's a very slippery slope. Item 2 on page 2. Staff proposes that the Commission adopt a regulation defining willful under this definition as it has been applied in practice by the Commission. A city employee or officer who withholds records in good faith reliance on the advice of the City Attorney's Office has not willfully violated the Sunshine Ordinance. Staff proposes that the Commission's regulatory definition of willful violation should address this common scenario by clarifying that an action taken in good faith reliance on the advice of the city attorney cannot be a willful violation of the Sunshine Ordinance. I would also add this, and that is there is a very clear section in the Sunshine Ordinance which for years has been ignored, and that is that the city attorney is not to advise on the denial of documents. And that is just constantly happening over and over and over again. It's obvious, it's clear. It happens here all the time, even though the city attorney doesn't show up in person anymore, as they used to make the argument for the departments. The arguments they get in their letters are from the city attorney, and that ought to be something that the ethics and this body should take up very seriously.
Thank you, Mr. Warfield. Additional public comment?
Yes. I think this is a positive step, and it's been years in the making, and I don't see any reason to put it off for another month. If all that's required is that you're going to respond to them, that you'd like to have another meeting with them or whatever you're going to do with them, I think that you should recommend that they adopt at minimum what they have given you here, but that there are other requests that you would like to make, and I think that should be. You should inform the commission that you would like them to move forward with this as soon as possible. I do have one question, and that is set forth in item number 1. Sunshine Task Force referrals will be formal complaints. He says the staff proposes amending the enforcement regulations to provide that any complaint referred to the commission by the task force would be processed as a formal complaint. Under this proposal, the executive director would be required to process and review all task force referrals and could only dismiss those matters in certain circumstances as set forth in enforcement regulations. Then the next sentence he says, when it accepts such complaints, the commission blah, blah, blah. Does that infer that he does not have to accept complaints, that he could reject a complaint? To me, that's the part that's not clear, because he says, first place, he says that all complaints will be processed and he'd be required to process and review, but it doesn't say that you have to accept them. And that's what I think needs to be clarified. So thank you.
Thank you. Public comment. Notice of public comment. Public comment is closed. Member Williams. Microphone, please.
I don't have a page number on here, but with the Ethics Committee, there's a paragraph here. It's not even, I guess it's supposed to be number 1. So I'm back as number 2. It has, the commission may adopt, amend, or rescind rules. Okay. Conflict of interest. I really want to know, break down what they call conflict of interest. And they have in here in bold letters, in addition, the commission may adopt rules and regulations relating to carrying out the purposes and provision of ordinances regarding open meetings and public records. What does this mean? That they want to change how Sunshine is written now concerning our regulations and our policies regarding open meeting and public records?
Where are you? I'm sorry.
Yeah, I don't
It's on
know.
the second
These
page, I
pages are
believe.
not- I mean, this is what gets me so mixed up when pages are not numbered. We're on the ethics. Okay, the ethics, there's no page number.
It is page right hand corner.
Where is the
lower
page?
right hand corner?
On the right-hand corner?
Yes.
Page 3. Is that what you're talking about?
I don't know where you see it, Sue.
All right. Anyway, there are page numbers in the lower right-hand corner of pages 2 and on. Not on page 1, but on pages 2 and on, there are numbers.
Okay, on page 2 on and on. Okay. That's what I was saying.
So,
oh,
I'm sorry.
You got page 4? You see page 4?
Yes.
Turn over to page 4, and in my package, it's memorandums, proposed amendment, revised ethics.
That's Alan Grossman's comments.
Huh?
That's Alan Grossman's comments.
Okay, that's Alan Grossman's comments. Okay, all right then.
I have a
Member
comment.
Coffin?
I mean, this is something that is so basic to what we do. And I would, we're talking a little bit about having 2 meetings a month. I would suggest that we set this for a separate meeting. You know, we're getting it now. We're tired. We've been in here for, 2.5 hours? I think we should set it for a separate meeting. We can have my comments, Mr. Johnson's comments, and we can ask Mr. Grossman to come and, he's filed a lawsuit against the Ethics Commission. I think that this is an important enough issue for us to take it up at a separate meeting. And I wouldn't mind spending a couple hours or an hour and a half to come up with a final document. That would be my suggestion. I'll put it in the form of a motion if I need to.
I think it's that's through the call of the chair, but agenda items, I believe, are only through the call of the chair. I'm not sure a member can move to put an agenda item, or a member can move to have a special meeting. So
I'll make it as a recommendation.
why don't you make it as a recommendation to the chair, and that will be at the call of the chair. I think that's the appropriate way it's done.
And Member Chairman Craven, when you make these meetings, some of us have other lives and other things that we have to do, and we can't meet all these obligations. So therefore, we have to call in and be excused. I mean, I'm into more than this for the city. I'm not my own personal life. So whoever sets these dates, they don't call and ask people, are they available? They just sets the date and go on with it. But I mean, I have other things in my life that I have to do. So if you're going to set special meetings and such things, we need to be notified if we're available. So maybe I personally can switch something else, because I have critical things that's going on in my life beside this right here that deals with the city and deals with the citizens of San Francisco.
Thank you. So that will be through the call of the chair. That's up to Chair Nee when he is back in service.
Does anyone know parenthetically, does anyone know when Chair Nee is expected back?
I believe within a week or so.
Terrific.
Yeah. So that's to his call. However, as acting chair, I will move without objection, or we can take a vote. This will be continued to the next meeting. The administrator shall include not only the proposed rules, but all public comments and comments received by the members in the agenda packet, so we can have time in advance to review them. And also that any members who have substantive comments, please get them in writing to help us all, and get them to the administrator sufficiently in advance so that they may be in the agenda packet.
And then,
Okay, I'll second that.
Chairperson,
Without objection.
excuse me. Again, the meetings, as Member Washburn said, when we put so many things on the item, the agenda, it goes so long, and we start losing people, and really we start losing focus on our own self. And it's really true. We not really grasping what the people are saying. So we need to take a look at that too, how we can schedule what we put on the agenda so it won't go like so late. I mean, last week was really late, and I mean, I guess that's what the gentleman was talking to. I wasn't getting ready to leave, but I was tired, and I was, and he told me to sit down, because we wouldn't have had a quorum, because everybody was getting up leaving. But Mr. Goldman, he never leaves, and you never leave, Miss Craven. But Miss Cawthorn has to leave sometime, and different people have to get up and leave because they have other things to do. So it runs too late.
Thank
the
you.
agenda, when it gets to be 20 and 30, that's too much.
I believe we have an item on this later in the agenda.
Okay, we do. Okay, thank you very
Thank
much.
you. Without objection, that will be continued. And I appreciate members of the public showing up and sitting through to only hear that it's being continued. We really do respect your input. And thank you for showing up. Next item.
Item number 7 is the report by the Compliance and Amendments Committee.
The Compliance and Amendments Committee met on January 12th to hear matters in compliance and amendments. The only issue of substance, I believe, in terms of complaints referrals that we handled was the complaint by Ms. Mabott against Park and Rec for failure to post audio of the commission meetings on the website within the time specified under new 6417C, I believe. I may have that wrong. But the requirement to do so, Park and Rec and DT, Department of Technology, submitted a response indicating that currently the client interface, and I may use the wrong technical terms here, that allows departments to upload documents to the city website currently does not automatically allow or doesn't really allow for the uploading of audio, that a special patch or authorization has to be done to allow departments to post audio. That's in our agenda materials if anyone is interested in looking at that. And that the city plans to, DT is working with departments to fix that problem by the end of the fiscal year, which would be by this July, and to basically provide for the mechanism of complying with that law. We invited through, I think Member Washburn was particularly adamant, she can correct me if I'm wrong, that we shouldn't let DT or Park and Rec off so easily, and that they should come back with us with more firm dates in writing and a progress report in advance of our next meeting, because this is now a law that's been passed for at least, I believe, a year, or if not more, and has certainly not been complied with, and yet, for example, our administrator was able to comply with that without too much rigmarole. So it seemed that there might be some holes in DT's position, or at least some sticks which we could use to encourage them to provide this mechanism more soundly. We are also still continuing with the issue of electronic records and preservation of emails. Member Washburn has found some general standards that apply in industry and in government. We are going to invite, or we have invited, but have not heard back from representatives of the Committee on Information and Technology to report to us on the status of the city's transfer to the hosted Microsoft Exchange platform away from Lotus Notes, and to also update us on the progress for a request for proposal for a contractor to meet with departments to go into what sort of specifics departments need in terms of retaining email, accessing email, responding to public records requests, responding to litigation. We don't know whether the RFP has been issued, who it's been awarded to, whether it's being implemented, what else COIT is doing with respect to discussing with departments and hopefully with bodies like ours on what should be required to make sure that our emails are being preserved and can be retrieved. So hopefully we'll have an update from them the next meeting. And finally, we are still working on the amendments. It has been a long haul. My goal is to, over the next 2 or 3 meetings, is to finally wrap it up, to really say this is what the Compliance Amendments Committee and the full task force missed. This is what needs to be addressed. Here's the problems in the copy of the ordinance that Frank Darby did. There are some errors in there that need to be rectified, and really move it forward. And it's going to take a lot of work by all of us to do so. But we've spent a lot of time. We need to push it forward and see what the feedback is so we can move it forward and reach a final resolution on what we're going to do. So I encourage participation in that process by everyone here and appreciate participation by members of the public as well. That concludes my report. If any other members would like to add. Member Washburn?
I don't have anything to add about the meeting, but just something I was thinking about when we were looking at the Ethics Commission's proposals, that it seems to me we should work between our responses to them and our proposed new amendments to the ordinance, and make sure we're clear about how we, want to work vis-a-vis the Ethics Commission. What our authority is. How do we make sure it's clear in the amendments to the ordinance? It seems to me we want to have our strongest position and convey it to the Ethics Commission in our response, and that might be a way to help guide the discussions in both cases.
Excellent suggestion. Seeing no further public comment on the Administrator's report? Public comment on the report of the Compliance and Amendments Committee.
I didn't see any minutes or draft minutes in the agenda packet for that committee. I don't know what the status of that is, but thanks for the verbal report. I just want to point out that there are actually three groups that are posting all their audio online today with the city. SOTF posts their audio recordings. Board of Supervisors posts the video and audio recordings, and then Ethics Commission posts their audio recordings. So it's not, I'm not aware of why there's a problem for other departments to do it. I would say that if you can post the audio on YouTube, you can post it on podcasts, and a lot of people download them from iTunes. I would suggest that you invite the relevant parties that are dragging their feet to come to every meeting and provide status on it, a written status in advance of every meeting until it happens. That's definitely your role as a Sunshine Task Force to make sure that departments adopt Sunshine. And let's say something else about CAC, but I would say that there's been an ongoing complaint about the speed at which orders of determinations are being produced when there's a determination made by the full body and sent to CAC. There's actually been quite a lot of email traffic about it. People are getting pretty upset about it. So I would encourage the task force to try to look into find out what's causing the delay in getting orders of determination produced.
Thank you. Further public comment?
Peter Warfield. I guess I'll just have to come up with another F word, a feeble complaint, no minutes. The Sunshine Ordinance says that the draft minutes of each meeting are supposed to be available for inspection and copying upon request no later than 10 working days after the meeting. It seems to me that today is close to or past that date for a January 12th Compliance and Amendments Committee meeting. And I haven't heard any explanation of why there is nothing in the agenda packet for this item, and for that matter, apparently not until item 10. Sounds like you're doing important and worthwhile and good work and dealing with important issues, and would certainly encourage you to go on with that, although perhaps it needs to be documented and perhaps at some point a plan for bringing it to the full task force so that the public and the full task force can be aware of some of the issues and some of the things that you are presumably accomplishing. The previous speaker, Kimo Crossman, mentioned orders of determination. Those most certainly are an issue, and the speed with which those have come down have repeatedly, the lack of promptness. Let me remind you that the law says, as I understand it, that there's a requirement to provide the complainant within 5 days of a hearing notice of what the outcome was. But in any case, the lack of these orders of determination is really impacting in a very negative way the work of compliance and amendments and education, outreach, and training, so that repeatedly in the last 6 or 8 months when I've been here with an attempt to make progress on complaints, I've taken the time, and it's not an inexpensive, no-value thing to come to a hearing, and then have arrived and found that, oh, they didn't get the order of determination until just today or a few days ago, so the committee is unable to expect compliance as normally would be expected had it been done on time. And now we have another meeting at least, and we've wasted everybody's time at that meeting. Finally, I would say that I'm very concerned that there's a split in compliance tracking between apparently compliance and amendments and education, outreach, and training. What that means is extra work and extra time for somebody who may have more than one complaint at a time. And it also is simply inappropriate, I think, to do compliance in 2 committees unless there's a very clear reason as to why. And I think this is a real problem here for yourselves and for the public.
Thank you, Mr. Warfield.
Thank you.
Additional public comment.
Yes, Doug Comstock again. With regard to the audio files, it's been over a year, and I don't know if Supervisor Mercarimi has been informed about the ongoing problems with it, but since it was his legislation, I would think that you should be able to corral some help from him in getting this taken care of. I myself, it's taken over a year, and I'm feeling like I'm beyond patience with regard to fulfilling this or complying with this, and I don't understand why they're dragging their feet on it. The other thing I wanted to discuss was the amendments and when they're going to be done and what the deadlines are at the Elections Commission to get them on the ballot, and when you have to have them to the Board of Supervisors for their approval. Are all these deadlines are we cognizant of the deadlines? We're going to make it for this November ballot. I really think it's essential that you have it for this November ballot, and I hope that that's all being taken care of. Since I'm not here to do it, I hope there's someone who is doing it, and I don't know that that's happening, but I hope so. I hope
you can always prod us.
Okay, I'm prodding you then. I also wanted to prod you to be preparing a summary of the substantive changes that are in it, which could go to the press and should be going to the press as soon as possible so that the press becomes involved in this. I think that's one thing we did with Prop G very early was to send out information to the press all the time. There were emails. I had a mailing list which I compiled that went to every single reporter of every newspaper, no matter how small, or in every newsletter for every neighborhood, so that people knew what was going on. And I think you need to get some kind of list like that going and get the summary out so that people know this is coming up and how important it is, and that you're not resting on your laurels, because I know you're not. I know how much work this is. So thank you for that, and I hope you're doing all those things.
Thank you. Yes?
I wanted to make a comment on what former Chair Comstock said. I just think it's really incumbent upon us, when we get the amendments done, to be really tight on the timeline. 2 years ago, we failed to get it on the ballot because of a glitch with one of the supervisor's office. And this time we really need to work with a supervisor who's organized, who knows how to get things done, and who, when you tell him the deadline is August 14th, he's got it for you by August 13th, and I'm going to suggest Chris Daly. But I think it's just totally important that we know when the deadline is, and we push whomever we're going to ask to carry it for us to make that deadline.
Yeah, just for information, we have asked Mr. Rustin to contact Department of Elections and have for us for our next meeting the final deadline as to when this all must be done. When we have that information, we will certainly publicize it and do 150% to make sure it happens. Seeing no more public comments, that item is closed. Next item, please.
The next item is the administrator's report.
Report Education Outreach and Training.
I'm sorry. Yes, item number 8. Report from the Education Outreach and Training.
Okay. We met on January 14th, and we're hoping to have the minutes in 10 business days. We had a problem in our last meeting that we have had before. We did not have a quorum.
More microphone, please.
Sorry?
More microphone, please. Someone couldn't hear you in the public.
Why is this thing not? Okay. All right. Yeah, we didn't have a quorum. We did have Linda Avery, who was there from the Historic Preservation Commission, to report on how she is responding to our complaint. We also had Rick Hillis from the mayor's office to talk about the Anne Marie Mabbitt complaint. So I elected to do something the task force used to do 10 years ago, and that we have done in the past. We simply proceeded on an informational basis. It was not a meeting. It was an informational gathering. We took notes. We did not take minutes. I was there before 4. Suzanne Monet came at 4:10. And we did hear from the Historic Preservation Commission Secretary, Linda Avery, who provided us with some documents as to how she had was now providing public comment in the minutes. We offered to make a presentation to her group or to the planning department also. I don't know if that's ever going to come to fruition, but she was rather pleasant about it. Rick Hillis from the mayor's office who was in high dudgeon, if I can use that phrase. He apparently had gone to a different committee, and now he was at our committee, and he was mad, and he didn't know why he was there, and so on and so forth. And he indicated that he had complied, and I made an offer to do a presentation, and he said we don't need a presentation, and he turned on his heel and stomped out. So that was the extent of our interaction with city officials. So. One of the problems we have at the Education and Outreach Committee, as I have mentioned before, is attendance. This time I think there was a problem with the quorum call. I know, and there was a problem with packets. I didn't get a packet. And we have 5 members, so that means we have to have 3 for a quorum, and we only had 2. So I'm going to talk to Chair Nee when he's up to it. About making some changes so that we are assured that we have a quorum. We can do a certain amount of have a certain amount of activity when we don't have a quorum, but we can't take any formal actions. So I mean, my feeling is we're going to have to hear back from Ms. Avery at least, because we couldn't take a formal action as to whether or not we should send it on to CNA or whether we should say you have complied. So that's my report. And if does any other member have anything to say?
Member Chan?
Yeah, I wasn't informed that we have a meeting on that date, and I usually get an email, and I never got an email notifying me on that day. I would have come, and I of course never get a packet, but that doesn't matter because I have the good old iPhone that I could get all my downloads on and all the packet in my iPhone. But in future EOT meetings, I would like to get emailed, so it's like a reminder. Or I think everybody should get an email in their committees reminding them to come.
Well, I think if that's only necessary if it's a special meeting. If there's a meeting that's set on a particular day of the week each month, it's incumbent on us to just put that in our iPhone calendars, by and large. But if there's a special meeting, or if it's a new meeting time, a new meeting date, that would be good as well. I mean, the administrator will discuss, has a lot to do, and there's been some lagging. And so we really should only be putting more on him to the extent that it's completely necessary. That would be my suggestion.
I had something to add. I have indicated that we should do a quorum call each month. And also, when we have tried to reduce the number on the committee, people have been very unhappy because they want to stay on the committee. And we are doing a lot of stuff which I forgot to mention. We are presenting before the Police Community Relations Body in North Beach. In February, we've also been asked to speak before the Coalition for San Francisco Neighborhoods. We have the Shelter Monitoring Committee. We have the Pedestrian Safety Committee. North Beach Neighbors wants us in March. And I personally would love to do a presentation for the Human Rights Commission. We're certainly going to do some outreach to them. And the other group that really does need some sunshine is the Mayor's Office of Disability. I mean, they don't even post notices of their meeting. They say they're a passive meeting body and they don't have to abide by sunshine, but I think they do have to post notices. So we've got our work cut out for us.
Thank you. Public comment on the report from the Education, Outreach, and Training Committee.
Peter Warfield, Executive Director of Library Users Association. The F word that applies to this meeting, I am very sorry to say, is farce. It began with a single member, the chair, and relatively soon joined by a second member on a 5-body member. This was not a legal meeting of any kind, and to call it informational gathering is essentially to evade the whole concept of the purpose of a quorum. You have to have a quorum to go ahead with a meeting for a variety of reasons, which I won't go into. But to go ahead with a meeting with no quorum, I think, is appalling and, I think, illegal. You put people into a whole odd position. Are there to be minutes or not? Why is there nothing documented about what happened and who spoke? Who was there? What was agreed or what was said to supposed to happen? There was a great deal wrong with this committee meeting, and I have already sent a letter to the chair and to the administrator requesting that the follow-up on the HPC order of determination as to what they, with respect to their unlawful minutes, be done by the full body and not by the Education, Outreach, and Training Committee for a variety of reasons, including, among them, that this was the second so-called meeting in a row which they went ahead with despite having no quorum. They couldn't get 3 people to come. We heard several times about the wonderful attendance of Ms. Avery, and yes, after not attending a number of times, that was great. We heard nothing about my attendance and about the fact that an architectural preservation historian, Mr. Bradley Wiedmeyer, also attended and gave testimony in behalf of our case, that the HPC did not satisfy the order of determination by what we had seen, although nothing was in the agenda packet with respect to anything from them in terms of a letter or any other thing. Now, at the beginning of the meeting, Ms. Avery handed Ms. Cawthon a packet of what I learned from Ms. Avery privately was the minutes of the last 3 months. I didn't get a copy of those. No copy was made available to the public, and an immediate disclosure request that I made to see those minutes was not satisfied until Mr. Rustum just now gave me what appears to be a photocopy of those minutes when I specifically requested originals. We ended the meeting hearing Ms. Cawthon saying thank you for their compliance, though nothing had been submitted, and I ask you to stop these farces and to take this matter up yourself at the full body. Thank you.
Thank you, Mr. Warfield. Additional public comment?
Hi, Kimo Crossman. I didn't attend this informational meeting, but from what I've heard, it doesn't sound appropriate. I would encourage that you work with your members to not have meetings that do not have quorum. Do meetings that do not have quorum, are they recorded? Is it required to record them? I don't think so. Is there a requirement for Chris Rustin to take any minutes? I guess not. Is there public comment at meetings that don't have quorum? There's not a meeting, so I guess there's not a need for public comment. I don't think it's completely inappropriate, and I've been to library commission meetings where commissioners didn't show up and they waited half an hour, and when they didn't have quorum, they canceled the meeting. And that was on the advice of the city attorney. You can't go ahead and have a meeting and call it an informational meeting just because you don't have quorum. If you want to cancel it and go meet off at a coffee house somewhere and reschedule it, that's fine, but you can't have it in the same location using city resources, using city staff, and giving people a nod and a wink when they present their department's response and saying, that's okay, thank you for coming, when the reality is they have to come back anyway if it wants to be legal. So there should not be non-quorum meetings. And of all bodies to be doing it, Sunshine should not be having non-quorum meetings. Thank you.
Thank you. Further public comment?
Well, I want to commend the two members who did come to the meeting, and their time is valuable too. And the fact that they did show up for a meeting and they did attempt to deal with some of the business, I think should be commended. And I'm sorry that there was not a full quorum and I'm sure that will be taken care of. But I think that we've been in this situation before, and often when you start a meeting, some people are late, and so you sit down and sort of start the meeting and wait for them to come, and I understand that. And I think that Chair Cawthon does a good job of chairing meetings, and that we should give her some slack on this as much as we can. Thank you.
Thank you. No further public comment. Member Cawthon?
I just wanted to give some points and authorities, as they say. When I first joined the task force about 10 years ago or so, we didn't have quorum either. It was before Prop G, so it was probably longer than 10 years ago. And we had a city attorney who sat at our table, and we used to simply hear from people. We would make comments among ourselves. We would take notes. And it was not an ideal situation, but it, at that time, was the best that we could get. Ernest Lorente, when he was our city attorney, said it was quite appropriate for us to have an informational gathering, or as I call it, an informal gathering. We take notes. We do record the meeting. The ideal situation is for a quorum to come, but if a quorum does not come, I think, you start the meeting and you think, well, people are going to walk in. And in this case, we had one person walk in, but we needed two to walk in. One of the problems that we have is that we don't have an attorney. And that would have been very helpful if we had the attorney who would be there to give us credence. I noticed that he has gone today also, and I'm not sure if that's a financial move or what, but I know the Library Commission doesn't have an attorney anymore either. So that's the problem. But what we do is we do the very best to accommodate people. We've had a lot of trouble getting Linda Avery to come because she had another meeting at the same time, but it was just down the hall. So in December she came, but she could only stay 20 minutes. So I said in January that she should come and stay until we were through discussing the matter with her, and that if she couldn't come, she should bring somebody else. So she did come and did bring the documents to prove that she was now doing the minutes in a sunshine-friendly fashion. However, she did not give them to us ahead of time, so we couldn't send them out in the package. I didn't even know that she had a document until somebody handed it to me. When I left, I just swept everything into my briefcase. But I did bring the minutes to the library CAC on, was it last Wednesday? And unfortunately, Mr. Warfield was a no-show, so I couldn't show him the minutes. But, I'm just making the point. There's only one member here now, but we really do need you to come to meetings.
Right, and just briefly, I mean, I've asked that we have a brief presentation from DCA Treat on what's to be done in the lack of quorum situation. I know the Good Government Guide requires that a meeting must end, but then once it ends, members of the policy body may remain to discuss any matters they choose with members of the public who have attended. And if documents are collected, notes taken, or a recording made, they may be presented at the next meeting of the policy body or of one of its committees, so they may become part of the policy body's record. So that's in the Good Government Guide. I would also suggest that because of budgetary issues, our DCA left this meeting early because with consultation with the acting chair, it was felt that his legal advice would likely not be necessary for the remainder of the meeting. It's an issue. It's an issue not having a city attorney at our meetings. However, and I think there's a movement afoot to try to get more hours allocated to the task force. But until or in lieu of that happening, call the city attorney. If you're unclear about what you can do in a meeting and there's no city attorney, call the office and ask to speak with, obviously, Mr. Threet. If Mr. Threet is not available, on an issue such as that, a general issue of public records or public access law, can we have a meeting? How do you take a motion? How do you do a split vote? You could also call someone on the government team and have Mr. Rustin do that. So those are just some suggestions. I understand we're all operating the best we can, but hopefully Mr. Threet will be able to give us a brief presentation as to the boundaries next week or next meeting, and the city attorney issue will be resolved soon.
I'm just going to reiterate what I said about the authority. The Sunshine Task Force itself used to have meetings when they didn't have a quorum, and former CAO Ernie Lorente said it was appropriate to have an informal gathering. However, we certainly can send out a quorum call, and if we don't hear from a quorum, then we can skip the meeting. My preference would be to go ahead with the meeting and assume that people are coming, but if they don't, I would feel that it would be okay to conform to our previous practice and simply have what we call an informational gathering with notes rather than minutes.
Right. Member Cawthon, I would request that you confer with Member Nee about this issue of quorum call.
I talked to Member Nee about it, and he said I did exactly the right thing.
No, that was not my point about the issue of quorum call that you were suggesting, whether or not that should be mandated or it should be instituted. My personal preference and my expectation as on the Compliance and Amendments Committee and whenever I'm acting chair is that members of this commission or of the committee who cannot attend a regularly scheduled meeting notify the chair and the administrator. That way, I or whoever is running the meeting will have notice if there's lack of quorum and can make the decision to cancel the meeting in advance. I don't believe we should. I think we should be responsible for ourselves, and if we know meetings are occurring and we need to be excused, do so in advance and communicate that to the chair of whatever committee it is or the full task force and the administrator. That way we have that information. That to me is much more efficient way of proceeding. Anyway, we've already had public comment on this. We're going to close the discussion. Member Williams, and we'll move to the administrator's report.
Oh, yes. I just want to say I have been on this committee with Sue for over 10 years, and she does do a good job. She fairly gives assignments out. But during this last year, even this board has not even sensitive to each other. And I did get, and you said that you made the comment that there are some members still want to stay on there. Yes, I said I still wanted to stay on there because Member Nee did not know what had happened or did not care what had happened in my personal life. I have lost 2 children within the last year and had a stroke. I have heard nothing from this is the only organization that I did not hear from. Member Nee called me on a Sunday and asked me, do you want to stay on this committee or not? And I felt very offended. And I told him, yes, I wanted to stay. But if it needs to move on with just Sue or whoever, let it move on, because it's a good committee. But I did say that I would stay. But right then, at that particular time, I was going through a personal crisis. Nobody knew about it. Nobody doing. But I did hear from other members, throughout the city, Board of Supervisors. But I felt like he didn't come at me in the appropriate way, not knowing my condition or not knowing what had happened, So I did, Sue said that I would like to stay, but, it doesn't matter to me because I could be taken off.
I just will say one thing. I have worked with Marjorie for a long time, and we've done a lot of gigs together, and she's great to work with. And, I certainly would be happy to have Marjorie, Doyle, and Hanley and Suzanne as part of as the team. But the thing is about the team, they've got to show up. They've got to step up to the plate, or we're going to be in big trouble. So.
All right, thank you.
There has been not one time that I have not called you, Chris, has it? And I have asked to be excused. I've even brought you in a doctor's thing, haven't? Okay, I've been through all of that. Okay, so we want to get this straight. It's just not me just not showing up.
Correct, and I think it is, generally speaking, for all committees, it's an issue that the chair must be informed in advance if there's going to be a lack of quorum, and I believe that whether being forwarded by Chris or email directly, if people use email, requests for to be excused need to be made to the chair so the chair can make that call. But we'll work on that. And
I'm just going to say one final thing that I talked to.
We really need to wrap this up.
I talked to Chair Nee after this happened, and he said, you did exactly the right thing.
All right, thank you. Thank you, members. It's late. We'll move on. This item is closed. Let's go to the next item.
Item number 9 is the task force and committee meeting schedules. The question is, shall the task force and its committees revise their meeting schedules to enable the task force to meet twice a month?
I am not aware of who asked for this to be put on the agenda.
Chair Nee did request this at the last meeting.
Is there a comment by members? Seeing none, is there public comment on this issue?
Kiva Crossman, I think this was in response to the very long agendas that have recently been the standard for the SOTF. This was put on by Chair Nee, and so I would recommend that you allow him to call it back when he desires.
To the call of the chair. Further public comment?
Yes, Peter Warfield. There's something specific here and something not so specific. First of all, I think I'm among the folks that suggested that rather than having enormously long meetings which go on at great length, including Member Williams, one time that I hoped to have Ms. Craven Green's vote, but she left before my item was heard on that particular time. I'm not faulting anybody on a specific instance, but I do understand it can be difficult, but that's why I think the task force ought to be at least considering twice a month, or a flexible schedule that varies according to the workload, so that if you have a certain trigger point, you make another meeting, otherwise you don't. That may cause difficulties with the schedule, but I do think that you do need to give a fair hearing and to give a reasonable opportunity for both the public and yourselves to attend and to be, as it were, all there. So I would certainly recommend, as the previous speaker, that you certainly give Chair Nee an opportunity to weigh in on this. But I think that, in my opinion, that's what you should take very seriously. The other piece of this is that for many years, this task force met as it does on a Tuesday, and some of the subcommittees meet on a Tuesday. When the Board of Supervisors at that time, and for quite some time until Matt Gonzalez became Board of Supervisors president, the board met on a different day. It met for a long time on Mondays. So there was no conflict. The idea that you would meet now on the same day and at the same time, offset by 2 hours, as the Board of Supervisors, I think is just wrong. It's anathema. The Library Citizens Advisory Committee certainly had problems when the library scheduled important meetings on the same day as the Library Citizens Advisory Committee meeting routinely held on Wednesday evenings, and found it objectionable because presumably anybody who's conscientious would likely have at least an interest in what happens at such kind of meetings. And I think there are plenty of people here who are concerned about all kinds of public issues and city business. And the Board of Supervisors routinely have hearings, public comments, not even just at public comment, which is every meeting, but on multiple occasions, such as today on item 41, the health budget. And to have people, as I have done today, shuttling back and forth and trying to sit at 2 meetings at one time and make informed public comment at both is, I think, an impossible situation, and you should seriously consider changing your day of meeting to Mondays.
Thank you, Mr.
Thank you.
Warfield. Further public comment?
I think we've talked about this for years and years, and I think there's a lot of sanity to this idea, because these long meetings are deadly. And I think that also the idea that Mr. Warfield advanced of having an optional second meeting each month, but to have a day carved out for that, but that it could be optional depending on the workload, is a good idea. But that day would be set aside, and if it's necessary to have a meeting that day on that month, then that would be a thing to do. But I think it should be optional. And I also agree that moving it from Tuesday would be a wonderful idea, because it would give people a better opportunity to attend the other meetings that go on. DBI is over in the other area. PUC is meeting over here. Board of Supervisors is meeting over there. There are a lot of important things that are going down that citizens need to attend to. And I think you're getting short shrift because you're on this at this date. So thank you very much. Bye.
Thank you. Any comment from the task force? Seeing none, if the chair wishes to have this heard again, it's to his call to put it back on the agenda. Perhaps the chair will explore with the clerk of the board and with our DCA issues regarding the feasibility of having twice-a-month meetings and report back to us. That would be my suggestion for Chair Nee, and to put it on the agenda when he feels it's appropriate. That item's closed. Next item.
The next item is the administrator's report. Madam Chair, we have received 3 more complaints since our last meeting. 2 of them are 12Ls. Besides that, I have nothing to add. One of them might come.
All right. I'll briefly comment on the issue of the time it's taken for orders of determination and ethics referrals. I think some of the delay in the last few months is because of the holidays, but not all.